of substantiation.
Chair, I had a look at Advocate Norco's memorandum,
Yes.
except for two paragraphs which are very generic and which is
Yes.
common cause between the two parties.
Yes.
I take issue with every point that she
Every point.
makes
Yes.
in this memorandum, Chair.
Yes. Where is the first reason that she gives in the point? Let's deal with that, and then you can refer to
It will be 2.3, Chair.
2.3, yeah. Okay, what was that reason?
Chair, she basically talks that case 781 was dealt with by the Specialized Commercial Crime Unit in Durban.
And case 781 is the Pandey case?
Pandey case, Chair.
Okay,
Chair,
yes.
the Chair want me to read the...
If
It
that's
makes it
best,
easy.
you can read
Okay,
it.
thank you,
Yeah,
Chair.
if that's the best
She
way.
says, case 781 was dealt with by the Specialized Commercial Crime Unit in Durban and disposed of recently with a decision not to prosecute anyone, as there was no evidence to prosecute any person for any offence. It has been revealed by the SCCU, which is the Specialized Commercial Crime Unit, that the SAPS members who were charged with the investigation of this 781 case was gunning for the prosecution of a specific person, in brackets KwaZulu-Natal SAPS Provincial Commissioner Lieutenant General Nkubeni, and Mr. Pandey and Kolmadu were being pressurized to falsely implicate her in the commission of criminal offences, with a promise that they will be exonerated in 781. When the SAPS investigators realized that the PC cannot be charged in this case, 781 in brackets, simply because there is no evidence against her, one IO reportedly said that the SCCU prosecutor may as well just close the 781 case. It appears Mr. Pandey and Colonel Madu featured nowhere in the 781. Then, as the focus was on the PC, one then may ask a question: why was Colonel Madu arrested in the 466 case? The 466, that's the attempt to bribe myself, Chair.
Yes.
Was this lawfully justified arrest, or was it a way to pressurize him to implicate the PC, as he, Colonel Madu, even mentioned in his representation that he was being regularly interviewed by the investigating officers so as to falsely incriminate the PC, which he flatly refused. My response to that, Chair, is
Yes.
I respectfully disagree with the submission.
That is in what paragraph in your...
That will be paragraph 3, Chair,
Yes, okay, yes.
of my response. So my response, I wrote, Chair, I respectfully disagree with the submission by Advocate Norco that there was no evidence to prosecute any person with any offence in the main investigation pertaining to the 60 million rand corruption. The reference number in this case is Durban Central Case 781 of 9/2001. It is my submission that there is a prima facie case against Tosham Pandey, Colonel Naveen Madhu, as well as Captain Ashwin Narayan Prasad. For purposes of this submission, I refrain from detailing the evidence in this matter, save to say that it contains in excess of 20 lever arch files of documents, more than 200 affidavits, as well as a forensic audit report compiled by an independent group of auditors, namely PricewaterhouseCoopers. I find it objectionable that the Specialized Commercial Crime Unit from her office seeks to entertain and attach credibility to the claims of the suspects in this matter. Quite how it was revealed by the SCCU that SAPS members charged with the investigation of Durban Central Case 781 was gunning for KZN Provincial Commissioner Lieutenant General Nkubeni is unclear. This imputation is not supported by any evidence other than the contrived version of the suspects themselves. I, for one, have never expressed any desire to become the Provincial Commissioner of KZN, and neither have I applied for this position before. In my view, this is a fallacious argument, since the irregularities that were investigated occurred before the
Before the
2010.
appointment? Oh, before the 2010 Soccer World Cup, is that right?
That's correct, Chair.
Yes.
The investigation focused on irregularities before her appointment as Provincial Commissioner. It is thus ludicrous to believe that the suspects, i.e. Pandey and Madhu, in this regard. The investigating officer could not have attempted to falsely implicate the Provincial Commissioner for a crime that took place before she assumed the post. Her involvement in the matter relates to the attempts by her to interfere with the investigation after she assumed a position as Provincial Commissioner and not with regard to the procurement irregularities per se. The conclusion by Advocate Norco that neither Pandey nor Madu features anywhere, and I wrote in nowhere verbatim,
Yes.
is manifestly wrong, and this conclusion ought to be challenged. There is overwhelming evidence to support a converse conclusion. The question by Advocate Norco as to why Madu was arrested in a subsequent attempt to bribe me is rather rhetorical. A reading of case 466, that's the attempt to bribe me, will demonstrate beyond doubt that Advocate Norco's reasoning is fallacious and wrong. I find it reprehensible that the suspect's version of events is preferred by Advocate Norco. This is a worrying precedent. Okay, Chair, then the next one.
Yes, so but let's just get this one clear. Is my understanding correct that what Advocate Norco was saying is saying in paragraph 2.3, which you have already read of her memorandum, is that one, there is no evidence against Pandey and Mr. Pandey and Colonel Madu to prosecute them, and two, that those who were investigating that case were actually pressurizing them to falsely implicate the Provincial Commissioner of SAPS. That, is my understanding correct?
That's correct, Chair.
That's what she's saying.
That's what she's saying, Chair.
And your response is there is ample evidence, and you say there are more than whatever the number is of liver arch files of evidence. And in this paragraph, she has not said anything about having looked at that evidence. Is that right?
That's right, Chair.
Yes, okay. Continue.
Chair, then in her paragraph 2.4 of Exhibit Z in brackets H, she writes, the SCCU revealed the scheming and intercepting of phone calls of inter alia Mr. Pandey with a motive and agenda to falsely implicate certain people. They allegedly even went further to even boast to Mr. Pandey, telling him that they know what the defense in the 781 case will be, as they heard his discussion with a legal representative through the intercepted calls. In my response to that, Chair,
yes, okay, your response.
my response, Chair, is quite how the SCCU revealed the scheming and intercepting of phone calls of inter alia Mr. Pandey with a motive and agenda to falsely implicate certain people, in my opinion, is a mystery. The tenor and tone of Advocate Norco's assertions in this paragraph is indeed worrying and ought to be examined. In her own words, there is no proof of Pandey's claims, as she refers to mere allegations. The preference of believing the suspect's version over the police's version raises to my mind a question of serious impropriety.
Of course, generally speaking, there would be no problem with a prosecutor or DPP when looking at a particular case, and they look at the investigating officer's statement and so on, and they look at the statement by the accused or suspect, if he or she has made one, if they were to come to a decision in good faith that they believe the suspect's version rather than the investigating, that, generally speaking, should be no problem. You have no quarrel with that, generally speaking.
I don't, Chair.
Yes.
I don't.
It's only because of the specific circumstance of this one that you have a problem with that.
Well, Chair, and why I have a problem with that is the reasons that she advances,
Yes.
there's no substance.
Yes, yeah. No, yes, let's continue.
Her paragraph 2.5, Exhibit ZH, Mr. Pandey was even promised by SAPS members in the 781 case that if we falsely implicate the PC, that's now the Provincial Commissioner, they would get rid of the 466 case. It was further explained to Mr. Pandey that the benefit of this sort incrimination of the PC for them, SAPS members, will be that the PC will be forced to resign, and then Major General Booysen will become the next KZN Provincial Commissioner. Further, Major General Dina Moodley would remain in control of the secret fund. My response to that, Chair, in Exhibit 2I,
Yes.
other than the claims by the suspects in this matter who had much to lose had the investigation led to a prosecution, and conversely much to gain should they have managed to derail the investigation, there is no evidence whatsoever to remotely support the claims contained in this paragraph. In any event, why would the Provincial Commissioner be forced to resign if she knew the evidence against her were contrived? Furthermore, there is no guarantee that I would succeed her as a Provincial Commissioner, presupposing that she had resigned. For this or any other reason, her vacant post would have been advertised and prospective candidates evaluated for possible appointment. It is my submission that Pandey and company have failed to compromise me. They've attempted to have the investigation stopped. The Deputy National Commissioner for the Hawks, Lieutenant General Dramat, is au fait with the detail. When this allegation failed, they brought in an unsuccessful application in the High Court to thwart the investigation. After they failed to bribe me with 2 million rand in cash, they have obviously run out of ideas. To now suggest an agenda by myself to become Provincial Commissioner at the expense of Lieutenant General Kobeni is not supported by any evidence and ought to be rejected. Lieutenant General Kobeni has no control over the secret fund. If I had to succeed, the situation would remain the same. To postulate that Major General Moodley would therefore remain in control of the secret fund makes no sense and is in any event irrelevant.
Yes. But I just want to go back to the first paragraph that you dealt with, which contains Arwet Noko's reasons, that is 2.3. Am I correct in understanding that what she said in 2.3 of her memorandum includes saying there was no case in relation to the bribery case against Colonel Modu, or did I misunderstand that? In saying there is no case, does she include that one or does she not include that one?
Sure, I think she's dealing here with the main 60 million rand case.
Yes, okay, thank you. Yes, let's continue.
And then 2.6 of Noko's letter.
Yes.
The matter 781 matter, the 781 matter which forms the basis and reason for the alleged corruption of Major General Booysen by Colonel Madu was found to be non-existent by the SECU.
What is she saying there? I'm not sure that I follow. About non-existent.
I don't think she knows what she's saying. Yeah,
I can't understand. Yes, how did you respond?
My response there to Chair was, I've dealt with the Durban Central CAS 781 in paragraph 3, and that would be my paragraph 2.3 above. This submission by Advocate Noko, I repeat, is based on a fallacious argument.
Yes.
Then her 2.7, Chair, Major General Booysen is the complainant and the only witness in the 466 case against Mr. Pandey and Kilmadu. The very Pandey and Kilmadu who allegedly refused to pave the way for him to become the next KZN SAPS Provincial Commissioner by refusing to falsely implicate the current Provincial Commissioner, Lieutenant General Nkobeni. 2.7 of my response there to Chair. I am not the complainant in the matter of Durban Central CAS 466, that's a bribery. This is a disingenuous proposition by Advocate Noko so as to build a legend for imputations contained in paragraph 2.8 and 2.9 infra. For one, the state is the complainant in the corruption matter. I'm merely one of the many witnesses. Advocate Noko clearly doesn't understand my role in this investigation. She also chooses to ignore the fact that the Durban Central CAS 781 investigation was initiated by none other than the financial lead in the province, Brigadier Lawrence Kemp. It is inconceivable that Brigadier Kemp knew about my aspirations as alleged by Advocate Norco, unless he obviously colluded with me to discredit the Provincial Commissioner. Had Advocate Norco ever bothered to examine Brigadier Kemp's statement in Durban Central Cash 781, she would have established the origin and source of the entire investigation.
Yes.
2.8, Chair. The 466 case, the bribery case, is investigated by the members of the police who fall under the command of Booysen, who is the complainant in the 466 case. Their objective dealing with the case becomes questionable, especially with the Cato Manor case cloud hanging over their heads. This, I believe, would shake their credibility, and the court would view all these in favor of the two, Mr. Panda and Colonel Madu. My response there to Chair, Advocate Norco is mendacious in stating that the investigating officers' objectivity are questionable, especially with the Cato Manor case cloud hanging over their heads. The investigating officers in these matters are as follows. Then I mentioned the case numbers and the investigating officers' names, Colonel van Lochenberg, Colonel De Plooy, and Colonel Herbst. None of these investigating officers were ever attached to the Cato Manor unit. They are not implicated in the Cato Manor issue at all, hence their credibility cannot be questioned, as implied by Advocate Norco. In any event, it would appear that Advocate Norco is usurping the functions of the courts, as the credibility of witnesses ought to be pronounced upon by the courts.
Yes.
2.9, Chair. Major General Booysen, being the complainant in the 466 case, interfered with and exercised control in this case, even going to an extent of determining and deciding who visits Colonel Madu when he was detained in the Durban Central Police cells in the 466 case. This is exhibited by the letter that was issued on his direct instruction to the Durban Central Police Station, Brigadier V.R. Stokes. This letter, dated September 2011, addressed to all relief commanders and cell commanders, entitled Visitation Durban Central Case 466, in Madu, provided that the
provides that and then quote
on the direct instruction. Provided on the direct instruction for Major General Booysen, only the following persons will allow to visit him: 1 Major General Booysen and Major General Moodley, etc. What is amazing with this is that Major General Booysen issues an instruction regarding who must visit a suspect in a case that he is a complainant in himself. Further, he also has a visitation right in this, as it appears in the letter, him being mentioned as a number 1 amongst those who are allowed to visit Colonel Madu. By the way, what would a complainant want to visit a suspect in their own case for? That is unheard and smacks of an agenda. My response to that, Chair, Advocate Norco is seriously misguided to suggest that I interfered with and exercised control in Durban Case 466. Had she complied with the National Prosecuting Authority policy guidelines, she was at liberty to consult with me to establish the facts, which I shall detail now. As the provincial lead of the Hawks, it is incumbent upon me to exercise control over all investigations conducted by the Hawks in KZN. The National Directorate of the Hawks were kept abreast of, that's not Dramat, were kept abreast of all developments in this investigation. To suggest that I interfered with the investigation is akin to suggest that Advocate Norco herself is interfering with the functions of her subordinates. There is nothing mysterious regarding my instruction with regard to visits to Madu. Initial investigations reveal complicity by officers within SAPS. This entry into the occurrence book was made to obviate attempts by officers with malafide intentions. I've dealt with this matter regarding my being the complainant above. Once again, the tone and tone of Advocate Norco's contentions appears to be that of a defense counsel rather than that of a prosecutor. The fact that I had not visited Colonel Madu at all subsequent to his arrest, or that I have not personally communicated with him directly or indirectly, demonstrates that Advocate Norco's assertion that it smacks of an agenda is misguided, and I reject it with contempt.
Yes.
Advocate Norco's paragraph 2.10, the allegation that the accused in 466 Mr. Panda and Colonel Madhu wanted Major General Booysen to predate a report in the 781 case in order to have the Section 205 subpoena set aside, then in brackets subpoenas for access to the bank account records, and consequently bribed Major General Booysen to do that does not really hold water, because the fact that if there has been any corruption, in brackets bribing of Major General Booysen, that took place would not make the corruption and its successful prosecution impossible. As Sections 3B and 41B of the Prevention and Combating of Corrupt Activities Act 12/2004 state, the alleged report in the 781 case that it was alleged was to be predated to invalidate the Section 205 subpoena did not suffice to prove fraud or any offence against anyone, especially Madhu and Pandey, who are alleged to have bribed Booysen for predating of this very report. This report is made out to be the evidence in the 781 case to prove fraud against Pandey and Madhu, but one wonders why it would not be seen in this way by the SECU. If then there is no fraud that could be proven by the SECU in the 781 case, why would Colonel Madhu and Mr. Pandey bribe Booysen, or anyone for that matter, in respect of 781 case using this report? One would expect that they would know what is contained in 781 case against them, as they are part of it. They would know what they did not even know. They would know what they did.
What they did.
They did to even know what this report has against them, especially Colonel Madhu, who was then a procurement official who processed the accommodation documents leading to the 781 case. My response to that, Chair, Advocate Norco chooses to be deliberately obtuse. For one, there is indeed a strong prima facie case against Madhu and Pandey in Durban 781. The attempt by Colonel Madhu and Mr. Pandey to derail the investigation in 781 emanates from the unsuccessful application to have the Section 205 subpoena set aside. Although the report in question itself does not contain prima facie evidence of a crime being committed, predating the report to a date before the application for the Section 205 case have rendered the 205s and subsequent evidence obtained inadmissible. Information on this report contained evidence gleaned as a result of the 205s. In other words, if I had predated this report, it would have meant that the investigators had obtained the information illegally before obtaining the Section 205 subpoenas. Advocate Norco rightly indicates that Colonel Madhu was from the procurement section. He has inadequate legal knowledge to argue the points raised by Advocate Norco. His sentence, one would expect that they would know what is contained in 781 case against them, as they are part of it. They would know what they did to even know what this report has against them, especially Colonel Madhu, who was then a procurement official who processed the accommodation document leading to the 781 case, and then I say is incoherent and difficult to understand. For instance, how and why would Pandey and Madhu know what is contained in 781? They were the suspects in the matter, not the investigators. Furthermore, they knew exactly what was contained in the report since they had illegally obtained it. 2 copies of the report were found in Madhu's vehicle on 2 separate occasions. A 3rd copy of the report had fingerprints that matched those of Pandey on it. All this evidence is contained in the dockets and for some unknown reason appears not to have been considered.
Yes.
211 of Norco's memorandum, Chair.
Yeah.
Colonel Madhu alleges to have met with Booysen approximately on 8 occasions at Booysen's instance regarding the Cato Manor unit shootings incidents before the 466 case came into being. I will say no more regarding this issue as the Cato Manor matter is sub judice. This, however, indicates a history of some sort being shared by the two, Colonel Madhu and Major General Booysen. Now they are complainant and accused in the 466 case respectively. My response to that, Chair, Advocate Norco once again prefers to exclude reliable evidence in Durban Central Case 466 in favor of Colonel Madhu's allegations, who obviously stands to gain by making these false allegations. There's objective evidence in 466, such as cell phone tower and communication correlation analysis obtained from cell phone records of Colonel Madhu and Mr. Pandey. SMS sent by Colonel Madhu, affidavits from Brigadier Maronsela and Sergeant Governor, as well as the cell phone records of Colonel Madhu. Mr. Pandey and myself to prove that the converse is in fact true. It was Madhu, in fact, contacted myself on a number of occasions. The objective evidence will prove that the meeting took place before the so-called Cato Manor matter. I would venture to suggest that by not considering the objective evidence and to favour unsubstantiated submissions by accused smacks of an agenda itself. If Advocate Norco had regard to all the available evidence at her disposal, she would have come to a conclusion. She would not have come to the conclusion she has. Advocate Norco should be aware that my involvement in the Cato Manor matter is not sub judice and has been disposed of in my favour. That was at the time that Governor had ruled in my favour, Chair. Once again, the last sentence in this paragraph, in inverted commas, this, however, indicates a history of some sort being shared by Madhu and Booysen, neither our complainant and accused in the 466 case, respectively, is incoherent and difficult to understand. 2.12 of the memorandum, there is an assumption that is not substantiated by evidence that Mr. Pandey is part of the alleged bribing of Booysen and Madhu. This assumption is derived from the position that they both are suspects in 781 case. This will not stand in court as evidence for corruption against them. My response thereto, Advocate Norco fails to ascribe these assumptions to anyone. Neither the investigators nor I have come to this assumption. If she herself is coming to this assumption, she once again fails to consider prima facie evidence in 466. For instance, a statement of the person who drew the money on behalf of Mr. Pandey, Mr. Pandey's fingerprints on the documents in question, and the paper slips found amongst the money offered to myself, which is linked to Pandey's bank account, to name but a few. Then 213 of a memorandum. This is one of those your word against mine kind of cases, as it is Major General Booysen's word against Madhu's. However, Section 208 of the Criminal Procedure Act of 77 provides that a conviction may follow on evidence of a single witness. The cautionary rules may be applied by the court in this case, especially given the background of this case and the challenges. And the challenge here is that Booysen himself is alleged to be hitting back at Madhu for the damning information that Madhu has against him relating to the Cato Manor case. Madhu alleges that Booysen is trying to silence him with the allegation of the 2 million rand corruption for the damning information that he has against him. 822, a former SAPS constable, Sandesh Daniram, confirms the possession of the information about Booysen by Colonel Madhu in the form of discs. And my response thereto, this is not a matter of your word against mine. If Advocate Norco had regard to all the evidence, it would be clear to her that there is not only direct evidence, witness evidence, but also objective technical evidence and circumstantial evidence to support my version. No such evidence other than false allegations by the suspects exist to support Madhu's claims. The reference to Daniram's statement is rather surprising, as a careful examination of this statement actually confirms my version. Advocate Norco failed in her duty to study the outcome of my successful application in the High Court. See Booysen versus NDPP. Had she done so, she would have realized that no evidence, such evidence as purported by Madhu, exists. I fail to understand how Advocate Norco seeks to accept an untested and unfounded allegation by a suspect who faces serious consequences in this regard. I also quote a passage of a finding by the then appeal court in the State versus Zuma. I don't think it's necessary for me to quote that, Chair.
Yes, no, it's not necessary.
Then paragraph 2.14. If the legal strength of the Section 205 subpoenas was based on the date on the report as it is alleged, hence Colonel Madhu wanted it predated to invalidate the subpoenas, it is inconceivable that any person, let alone a colonel in the SAPS, a person of Colonel Madhu's caliber, who was working on these issues of procurement at SAPS, would not know that SAPS could simply obtain other Section 205 subpoenas that would tally with a new predated date in the report. His problem would not have been resolved. Therefore, one may ask, why would he bribe Booysen when this would not provide a permanent solution to his alleged problem? This dating of the report would not have caused any subpoenas to be set aside because it is not evidence 781. Neither does it have any bearing as far as the procedural steps and prerequisites for obtaining a Section 205 subpoena is concerned. This was proven by the SCCU in the 781 case. In my response thereto, I dealt with this adequately above. I would like to add, however, that Advocate Norco wrongly assumes imputed knowledge of law by Madhu. She herself points out that he works at procurement, who hardly if ever works with Section 205 subpoenas. What concerns me, however, of this paragraph is once again the tenor and tone of her assertions. She is once again deliberately obtuse and misconceives the allegations against Madhu. I find it disquieting that the SCCU seeks to prove allegations by suspects. Paragraph 2.15. Further, it appears that Booysen was not the investigator in the 781 case, but van Lochenberg, and others were. Therefore, a question arises that why would a favor of the predating of the report that should be in the possession of those who are investigating 781 case be sought from Booysen, not the investigators? My response thereto, Advocate Norco once again demonstrates her ignorance of the evidence at her disposal. The report in question was undated when I received it. It is common practice in SAP's communication protocol for the recipient to date, stamp and assign reports when they receive it. It is this date Madhu wanted me to predate. The fact that I, as a potential witness in this regard, was not interviewed is indeed worrying. 2.16 of her memorandum, the cell phone records purported to reflect the calls between Pandey and Madhu do not indicate any specific crime having been planned. It is haphazard conversations with slang and profane language between the two people that one cannot really make out what issue was being discussed, as a lot of different issues were being spoken about. More especially, a criminal offence cannot be deduced as constituted by the fact from the conversations in the cell phone records available. A question may be asked that on what basis was an inference drawn by the police investigators that these conversations pertain to or constitute a criminal offence being planned by the couple, specifically that they were planning to bribe Booysen. The alleged authority to intercept the calls for which Madhu and Pandey calls are alleged to have been recorded was issued during June 2011 for June to September 2011. This appears to go way before the 466 case. This then ties up with what the SCCU has revealed, that people's calls were being recorded and the period tallies with the 781 case rather than the 466. One then wonders if the 781 recordings are not utilized in another case, the 466 case, which is not permissible. And my response there to Chair, Advocate Norco, I respectfully submit, could not have listened to all the recordings between Pandey and Madhu. A conclusion otherwise would be irrational and subjective. It is evident that she has considered some of the recordings to the exclusion of others, which may very well have resulted in a wrong conclusion. It is common cause that Pandey's calls were intercepted prior to the 466 case. In any event, if she would argue that the recordings are admissible, it does not render them illegal. Furthermore, there is enough prima facie evidence to secure a successful prosecution in 466, that's a bribery case, without presenting the Act 70 interceptions as evidence. This, I understand, was the stance and view of the investigator. In conclusion, it is unfortunate that Advocate Norco seeks to accuse me of having an agenda in these investigations. Even if it was true, and I deny this strenuously, the AD has pronounced itself adequately in this regard. Then I refer to my quotation from the case of Mr. Zuma. I suspect that the converse is true. This matter has been outstanding for more than 2 years. I think it's no coincidence that this missive coincides with the renewal of the Provincial Commissioner's contract. That was the Provincial Commissioner Nkubeni's 5-year contract that expired, Chair, and this report by Advocate Norco coincided with the renewal of her contract. The fact that Advocate Norco has failed to return the case docket to the investigating officers in spite of requests by them and the subsequent timing of this missive leaves me with this inescapable conclusion. And then I hereby request you to summon all the relevant documents to your office and to have same evaluated by an independent team from your office. This issue has been widely reported in the local media. It has drawn various negative remarks from the public and commerce. It is in the best interest of the judicial system, the National Prosecuting Authority, the South African Police Service, Mr. Pandey, Colonel Madhu, and Narain Prasad, for these issues to be ventilated in an appropriate manner once and for all.
So, in her conclusion, in her memorandum, Advocate Norco, among other things, says that he has decided to decline to prosecute Colonel Madhu and Mr. Pandey for corruption or any offense in the 466 case. She says this is due to lack of reasonable prospects of a successful prosecution, as explained and substantiated above. Further, there appears to be agendas among the parties and the scores to be settled. So, but with regard to the Madhu corruption case, just to go back, your evidence was that he was arrested at the time when the actual money that he had brought to you as part of, for bribery purposes, was there. Photos of the money were taken. Excuse me. This happened at the basement of the building where your offices are. And there were police officers who were waiting for him to come into the building. They saw him coming in. They saw both you and him interacting. And as you were leaving, and you had agreed with them, that is the police officers concerned, that you would give a certain indication to say they must, in effect, pounce on him now. And I seem to think you could not remember whether you gave the indication or not last time when you're giving evidence. But they, while you were walking towards the lift, they jumped and they arrested him.
Chief, I did, my evidence was that I did give them the indication when I touched my head.
You touched your head,
and
yeah.
when I was scared that they didn't see me, I actually started slapping myself on the head to make sure that they see the signal. But over and above that, Chief, there's also the video recording.
There was the video recording as well.
Of him putting the money in my car.
Yes. And do you know personally that all of this evidence or statements by these police officers and your own statements, all of that were in the docket? You know that that was the case, at least before you were suspended or so on. As
Chair is aware, you have direct witness evidence.
Yes.
That was contained in the docket.
Yes.
You have circumstantial evidence.
Yes.
That was contained in the docket. There was technical evidence such as the fingerprints of Madhu on one of the documents. There was the evidence of Pandey's brother's girlfriend's father, who they taken to the bank to withdraw a substantial amount of money, which was linked to a piece of paper, a bank piece of paper, I think it was Nedbank, that was found amongst the money. There was the actual Act 70 interceptions. There was also the tower movement that we, 205. There was also the SMSs that he had sent me. That was downloaded from my phone and his phone. And in spite of all that evidence, she says there's no case. And then part of what you are saying, it's difficult to understand how she could say that in the light of that evidence that was there. That's part of what you are saying. To me, it's incomprehensible that you can come to that conclusion. Over the years, I've dealt with many cases. And she herself says that the Criminal Procedure Act
Yeah.
provides for single witness as evidence.
Yes.
But here it's not a single witness. She says it's his word against mine. There are people that actually saw that. There's a 252A from the DPP's office. There's the 252 coordinator. There's the investigator. It's just overwhelming, Chair. There's just no ways that anyone could come to a rational conclusion that there's no case against Pandey Madu.
Yes. And to the extent that she says, among other people, to the extent that she may be saying you may have had an agenda
Yes, Chair.
to have the provincial commissioner falsely implicated and prosecuted. Had she sought your own statement about that allegation? Had you been approached by her or anybody to say there is this allegation that you are part of an agenda to do this, and did you get a chance to refute that before you saw this memo?
Chair, not once. From my arrest, had I ever been given an opportunity
Yeah.
in terms of a warning statement or in terms of a response? Not once.
So these assertions that she makes in her memorandum, that at least we can talk about you, that you may have been pursuing a certain agenda about the provincial commissioner, and that you may have been pressurizing Pandey and Colonel Madu to falsely implicate the provincial commissioner. When she wrote this memo, she had never herself or through anybody put this to you to hear your version.
Never, Chair, not
Yeah.
once.
Thank you.
Thank you, Chair. Following the submission of your letter, was there any, did the decision change at all?
Chair, I think I testified about that earlier on. That's when, subsequent to this letter of mine, where Advocate, and just because this was addressed to Advocate Ntasana,
Yes.
and subsequent to that, a few things happened. One is that Advocate Jiba stood to be prosecuted for the cases in which I was the complainant. And Advocate Gerry Nel had been in the process of reviewing the withdrawal of these charges and the nollie prosecute. And it was at that point where myself and I think Mr. McBride, we thought we were on top of things. Now we were now at last making headway. Then the next thing, there was the newspaper article about Advocate Ngasana not being fit. And unfortunately, he was elbowed out and replaced by Advocate Abrams. So nothing came, as we speak to date, none of Pandey or Madu or Narain Prasad or General Kobeni has appeared in front of court on any of these charges.
I'm sorry, let me go back to this issue that we dealt with just a few seconds ago about Advocate Nono. The other persons that she is talking about when she says certain people have an agenda, apart from you, it would be who? Or do you not know?
No, Chair, I think she's referring to General Moodley.
Yes.
General Moodley was in charge of crime intelligence in the province.
Yes.
And
yes.
the guy responsible for the Act 70 communication interceptions,
Yes.
which is Colonel Padiachi, reported to General Moodley.
Yes.
There was, at that stage, Pandey allegedly was called in by Moodley and played some of the intercepts
Yes.
in order to force him to implicate the provincial commissioner.
Yes.
I'm not aware of that.
Yes.
I don't think that took place because when it was reported in the media at the time, Pandey quoted things that was definitely not said during the Act 70 interceptions, which he said he had heard.
Yes.
So I've got my reservations whether Moodley actually did that or not. I don't
Yes.
think it happened.
Yes, yes.
And I think she's referring to
Yes.
General Moodley.
But am I right to say you were one of the people she was including when she was said in the memo, certain people have agendas
Yes,
to
Chair.
falsely implicate the provincial commissioner?
Yes, Chair.
Okay, thank you. It's just that it seems to be concerning. I mean, she was acting in a senior position of deputy DPP in KZN. Wouldn't that be the highest provincial position under the the National Prosecuting Authority for the province? Or not really?
Chair, are you referring to Advocate Norco?
Yes.
Advocate Norco was the senior prosecutor in the province at
In
the
the whole
time.
province, yes.
Yes,
And here you were a very senior member of the police service, of a member of the Hawks. If there was such an allegation that you were involved in something so wrong, to have a senior, the provincial commissioner of police, falsely implicated, one would have expected that before she made a decision such as withdrawing charges, she would have at least heard what you had to say about this allegation that you were part of an agenda.
Chair, my response is twofold. One is I agree with Chair. That's a normal course that we always follow when there are representations from accused persons. But what concerns me most about this memorandum of her, it's almost an attack against me and the case. It makes me look like the accused person, and the actual accused persons like the complainants. The tenor and tone of her whole letter, I would have at least expected, as Chair says, to have at least given me an opportunity to state my case the way I did eventually to Advocate Ngasana.
Do you know whether she ever saw your comment that you sent to Mr. Ngasana? Or
I do
you
not
don't
know, Chair.
Yes, okay, thank you.
Thank you, Chair. If we can then move on to the next point that Chair had raised for attention, and that's the letter, the covering letter, specifically by Advocate Norco. With your leave, if I may hand up two documents. Please. Thank you.
What are these?
Yes. Before you, Chair, General Booysen had provided two documents. The first document, which is marked blue, which is a blue document, is the letter that Chair had requested. It is the letter from Advocate Jiba. It's the letter from Advocate Norco to Advocate Jiba, which is the covering letter that Chair requested, specific to the application for authorization of racketeering charges to
we'll
be
need
instituted.
to mark this as exhibit ZJ, yeah?
Yes,
The last
Chair.
one was I.
Yes, Chair.
This will be exhibit Z in brackets J. That is now the letter that is blue coming from Advocate M. Noko Mashilo, Acting Director of Public Prosecution, KwaZulu-Natal, and addressed to Advocate N. Jiba, Acting and National Director of Public Prosecution, dated 15 August 2012.
Yes, Chair.
I take it that Advocate M. Noko Mashilo is the same person that so far we've been referring to as Advocate Noko.
That's so, Chair.
Thank you.
Chair, this is but just the covering letter, and it does not include the annexures that are referred to in this letter. In addition to this document, General Booysen had also provided another letter.
Yes.
So if I may, Exhibit ZJ, as has been marked now, relates to the first authorization of racketeering charges. The next
okay.
document, which was also provided and yet to be marked, relates to the second authorization for racketeering charges. Chair will recall that the first authorization was done by Advocate Nomcobo Jiba, and
Yes.
the second authorization was by Advocate Sean Abrams.
Yes.
With your permission, are we to mark the next?
This
Document?
document will be Exhibit ZK, and purports to be an application for authorization in terms of Section 2, subsection 4 of POCA, 121 of 1998. It's from Advocate M. Noko, Director of Public Prosecutions, KZN, and is addressed to Advocate S.K. Abrahams and DPP. Yes.
If I may. General Booysen, if we could first quickly refer to Exhibit ZJ, that's the blue document. That's the covering letter that was sent by Advocate Noko to Advocate Jiba in relation to the first authorization of racketeering charges. Is that correct?
That's correct, Chair.
Okay. It specifically then talks to enclosing, as referred to in paragraph 1, an application paragraph 1.1 is the application for authority, 1.2 is the proposed indictment, and 1.3 is the draft authorizations. The recommendation is for the authorization to be granted. This particular document, while we do not have the annexures to this document, was signed in fact by Advocate Noko.
That's correct, Chair.
Okay. Do you know who signed the indictment that ought to have been enclosed with this document?
Chair, if my memory serves me correctly, I think it was Advocate Mahema.
Thank you. And are you aware whether or not, in accordance with procedure, there was a prosecution memorandum and or the PowerPoint presentation in support of this
I think there was a
application?
memorandum, Chair, but not a PowerPoint presentation.
Thank you. And is this the authorization that was then subsequently challenged, to which a finding was granted by Justice Govan?
That is so, Chair.
Thank you. If I can then move on to Exhibit ZK.
Chair, if you would allow me, I just want to
Yes.
contextualize the date on this report.
Yes.
This is not soon after Advocate Simpiwe Malocha was moved sideways
Yes.
and Noko was appointed. And this coincides with a number of events that occurred at the same time.
Yes.
During this period,
Yes.
I was still busy supervising the Panda investigation
Yes.
and the Amigo investigation,
Yes.
both which Noko subsequently withdrew
Yes.
and then recommended my prosecution.
Yes. Yes. Okay.
Thank you, Chair.
Okay. Thank you.
And then,
The events that you referred to that were happening around about this time, do you want to deal with them or not? They are not necessarily in your evidence.
But Chair, it is in my evidence.
Yeah,
but
okay.
I just wanted to bring it to Chair's attention that the timeline here
Yes.
is at the exact same time.
Yes.
It's after Malocha refused to withdraw against
Yes.
the people in the Amigo case, refused to sign our indictment, mine and Keita Manus indictment.
Yes.
He gets replaced.
Yes.
Noko withdraws those charges
Yes.
against the Amigo groupings,
Yes.
and also Pandey and Madu.
Yes.
And in turn, recommend my prosecution.
Yes. I don't know whether what I'm going to ask will relate to the next document that we have just referred to, which Ms. September will deal with, namely the question of whether when Ms. Nogo, if you do know, when Ms. Nogo recommended your prosecution, the documents that Mr. Mlotra, Adwin Mlotra had said he would not sign it if they were not before him whether they were before Ms. Nogo. You might or might not know.
Chair, all I can, the only response I can give is what she says in the letter.
Yes,
She refers to the application
yes,
in terms of section 2.4 of POCA, the proposed indictment,
yes,
and then the draft authorizations.
yes.
And then she says, I've perused the documents and
Yeah.
recommend the application.
Yes, but we don't know which
No,
documents she perused. They might or might not include the ones that Advum Lodra thought were important to be finished. We don't know. Is that right? Or we do?
I do not know, Chair, but
Yes,
I'll venture a guess that they weren't there.
yes. Okay, I think it will be important to establish, one, what the documents were that Advum Lodra was insisting should be there, because if he signed or recommended prosecution without them, it would be improper. And then, of course, it will be necessary to apply one's mind to the question whether he was correct on insisting on those documents. And three, whether in making the recommendation, Ms. Nogo had those documents. Obviously, if Advum Lodra was wrong to insist on those documents, then even if Advum Nogo recommended without those documents, that might not be anything negative to us. But if those documents were important to be before the person taking the decision to recommend, and she recommended without those documents, then one would need to look at that. Thank you.
As it pleases, Chair. Before we move on to the next document, this blue document is the first authorization in 2012.
That's correct, Chair.
The second document, which is Exhibit ZK, is dated 18 August 2015, which relates to the second authorization.
That is so, Chair.
Now, it is stated in your affidavit at page 23, paragraph 75.
I'm sorry, where are you?
In apologies, Exhibit ZA. It's in his main
That's the
affidavit.
one with the statement.
Yes, Chair.
Yes, what page?
Page 23, paragraph 75.
Okay. Yes.
What is recorded in paragraph 75 talks to the evidence that you've already presented, alluded to by the Chair, in that Advocate Mlochwa refused to sign the indictment until he received certain documentation.
That is so, Chair.
Was the refusal to sign the indictment then related to the second authorization?
Notice related to the first authorization, Chair.
Thank you. If we then look at Exhibit ZK, there does not appear to be many paragraph references, but if we look at page 2,
Page 2 of,
page 2 of Exhibit ZK.
oh, okay, of the statement.
No, Chair, the new
The table of,
the new document that we've just entered in. There's the blue one,
oh,
and
okay.
then there's the other,
ZJ,
ZK.
K. Okay. All right.
So-
What page on that one, or paragraph?
So paragraph 1 reads that this document is essentially an application for fresh authorization of racketeering charges against you and several others. On page 2, it talks to certain documents that ought to have been enclosed, which we do not have, in support of the application. And 1.1 lists it as the application for authority, 1.2, the fresh prosecution memorandum, 1.3, the proposed indictment, and 1.4, the draft authorizations. Is that correct?
That's correct, Chair.
Now, in this regard, earlier you referred to a prosecution memorandum and a PowerPoint presentation.
That's correct, Chair.
Are those the two documents that may have been referred to in this particular letter?
I suspect so, Chair.
Thank you. Just to highlight, on page 3 of the same exhibit, ZK, paragraph 4 details the documents / evidence upon which, or rather which were considered for purposes of this application. And in particular, it lists at least 7 points. If I could quickly go through them with your leave, Chair. Paragraph 4A informs, or rather paragraph 4 reads, I have received full briefings from the prosecution team and resolved that the concessions made by counsel on behalf of the ANDPP during the hearing of Booysen's application were incorrect. And it seeks to then address certain points, which is listed from A to G. If we could then turn to page 5, paragraph 6 talks to copies of affidavits or documents which are relevant to Booysen insofar as the racketeering charges and predicate charges are concerned, and in doing so lists various documents including the High Court application where Booysen is a respondent, documents relating to the monetary awards, statements of Colonel Aya dated 3 August 2012, 31 August 2012, and 13 March 2013. Statement of Benkinkosi Mtanyani Ndlondlo dated 31 July 2012. Statement of Andrew Carson Cochrane dated 16 May 2012. Statements of Commissioner Brown dated 8 and 9 May 2013. Statements of Nkosinati Hopewell Shozi dated 3 August 2012 and 15 March 2013. Statement of Simpiwe Cyprian Matonzi dated 15 March 2013, and statement of Bongani Mandla Mkize dated 1 August 2012. And it's essentially on the basis of this submission that at paragraph 8 on page 6, the request is made, or rather, paragraph 7 on page 5, where the submission is made that there is sufficient evidence linking them to racketeering and predicate offences, as will be shown in the fresh prosecution memo enclosed herewith. At paragraph 8, kindly indicate that you are available for a full briefing with the entire prosecution team. This letter is dated 19 August 2015, notwithstanding the date of 18 August 2015 on the front page. This is then the request for authorization under which you are currently charged.
That is correct, Chair.
Thank you, Chair.
Yeah.
If we could then go back to Exhibit ZG, which is the Mokoro report. Page 121, we've dealt with the prosecution memo, and without detracting from the detail that is stated in here, it continues to page 127, which very briefly, at subparagraph 5.2.1.13, deals with the manner in which the Booysen matter was dealt with. The next pertinent point is at the bottom of page 127, which talks about, or rather it is titled at paragraph 5.2.1.14, which is Mozing's version. Okay. Who exactly was Advocate Mozing in the context of the investigation?
Chair, it had become clear after Advocate Mamabolo and Advocate Kruger, who was in charge of the desk, to go through the documents before it's eventually given to the NDPP. When they were removed, Advocate Anthony Mozing then took over their position. I later on referred, when I talk about Mozing under the heading of prosecutors, Chair, but at this point, what I would like to mention is that on the 8th of March 2012, that was barely 2.5 months into the investigation after the Sunday Times report. I'm in possession of a copy of handwritten notes which Advocate Mozing kept, minutes of the meeting, in which where it indicates that there was a meeting between himself, members from IPID, ICD then, the Minister of Police, who was Minister Natim Tetwa at the time, and also the then acting National Commissioner, which would have been General Mkwanazi. He wrote Vilagasi, but it's actually Mkwanazi. Now, from those notes, Chair.
I saw those notes in your bundle. On Mr.
Yes,
Timber,
Chair,
do you
if
know
I
where
may?
they are?
If I may, Chair, yesterday during consultation with General Booysen, it's a document that General Booysen had prepared, which is a typed version of the copy of the note, which I will direct you to now.
Yeah, let's find them first, and then you can hand up the typed version. Let's find them where they are first.
Humble apologies, Chair.
Was it not
It is at
Annexure
page,
23 or something?
it's Annexure
12.
JB12, which is in file ZA, page 145.
Have you found them on Annexure 12?
Is that the typed version?
No, that's the
The-
copy
the-
that is in the file.
The handwritten one first, then we can look at the typed version.
What page is it?
It's an Exhibit ZA, page 145.
That's indeed the copy, Chair.
Let me just get the, I remember that I thought they were difficult to read. Yes, thank you. Then you say there is a typed version.
General Booysen had typed up his understanding of the note, and with your leave,
Yes,
I beg to hand it up.
okay. Did you find it easy to read this? I'm thinking how reliable your typed version is. If we got a typed version for the author, from the author, that would obviously be much more accurate. But you might, if you are able to read quite well the notes, that's fine.
The Chair, this copy is not very, it's not a very good copy.
Yes.
The one that the actual one is clearer than this.
Yes.
In the typed version, there's a lot of places where
you can't make
where
out.
it's impossible to decipher.
Yeah. Okay, so we can take this as as a typed version based on your understanding of the handwritten notes, and if and when Mr. Mozing does give evidence, he can tell us what his notes actually say.
Okay, Chair.
Okay, thank you. I think that one can put this, maybe one could put this, one can't put this in here because it's not part of this affidavit.
Correct, Chair.
So I think we must make it an exhibit on its own. The last one was K.
Okay.
So this will be L. That will be exhibit ZL. And it's the typed version of the handwritten notes at page 145 of exhibit ZA as understood by Major General Booysen.
Thank you, Chair.
Thank you. Yes.
Please proceed, General Booysen.
Chair, I'm reading from the typed version.
Yes.
The meeting was, it says 8/3/12 meeting with the ICD. Then there are 3 names, Gamanyana, Glenn Angus, and Mr. Kuba.
Yes.
And then it reads, first meeting with Minister of Police, SAPS, Acting National Commissioner Nhlanhla Vilakazi. I think you recorded that wrong because it's Mkwanazi.
Yes.
And then it reads on, merge 2 teams, full stop, mandate, matter pending since December 2011, hit squad allegations, on the typed version, Chair, those bold letters are my own bold letters. Well,
yes.
It's what I read from the minutes, but I've made them bold myself.
Yes.
They're not bold in the...
It's not bold in the minutes, in the handwritten notes.
That's right.
Yes.
So it says, once arrest by this week, worked throughout weekend. And then the other one, the underlining is also by myself, Chair, and the boldness.
Yes.
And that, this particular line, Chair, coincides with what emanated during the Judge Mokoro's Commission of Inquiry, or
yes.
the inquiry, not the Commission of Inquiry.
Yes.
Challenge to rope in NPA prosecutors, not submit to KZN, DPP, but to NDPP. And then it reads on, General Mabula met with Mlotshwa, promise, then I cannot figure out what's written there, and then join only next week. It mentions 51 cases, those J56 in brackets 19, inquest dockets 12, and then I couldn't make out what he wrote. Now 6 cases that are needing other investigation outstanding. I wrote verbatim, Chair. Brought 6 cases which they want to bring here, and fields, I cannot make out what he wrote. Once decision by tomorrow. Suspects, 12 in unit, Booysen, PCOC. That PC would be at the Provincial Commissioner's Office, at the Organised Crime Unit Office. Evidence of photos which General Mabula's team need to get. Way forward whether and prosecutor will join next week. ICD officers, Durban briefed NDPP. The things that I've highlighted, Chair, is it says first meeting with the Minister of Police, SAPS, and the Acting National Commissioner of Police. And it says merge 2 teams, mandate matter pending since December 2011, hit squad allegations. Once arrest by this week, work throughout weekend. Chair, my interpretation of that is, if you're there with the Minister, my interpretation of this is that was one of his demands. And then very importantly, Chair, challenge to rope in the NPA prosecutors, not submit to KZN DPP, but to submit to NDPP.
And the KZN DPP at that time, would it have been Advocate Mlotshwa?
That's correct, Chair.
Yes. Okay, thank you.
Thank you. And what exactly was your concern or problem with the recorder as you understood it to be in relation to the minister holding this meeting and calling for arrests within that week?
Chair, I might add that subsequent to the Sunday Times apologizing to myself, I had a radio interview with Karima Brown from 702 channel, where some of these issues were discussed. And when I left the studio, when I arrived home, I received a text message from Karima Brown from 702 that Minister Mtetwa had issued a media release gainsaying what I said during the interview. The following morning, she phoned me and said to me that she's inviting the minister to the studio to discuss these issues, and would I be prepared to come back to the studio? And I said to her, you can tell the minister I'll meet him in the studio tonight. And she said, would you come? I said, I would. I arrived there at the studio that same evening. He didn't arrive, so they dialed him in. And during this conversation, Karima Brown indicated to the minister that I'm in possession of these minutes. He was in the beginning a bit cagey about the meeting, that he hadn't seen the minutes. But then she asked him a very, very pertinent question, whether he had a meeting with the prosecutors, which he confirmed on national radio 702. She pointed out to him that he had no business meeting with prosecutors, which I agree with. He tried to justify his involvement by saying that there were allegations of human rights abuses, and he referred to one particular case where a person by the name of Mkhize got shot and killed. I expected him to use that example, so I took documents with me to the studio, which I gave to Karima Brown, because the Mkhize family had sued the Minister of Police, who was Minister Nathi Mtetwa at the time, for the unlawful killing of Mr. Mkhize. But the minister at the time, Mr. Nathi Mtetwa, had deposed to an affidavit in the civil matter, saying that the shooting by Cato Manor was justifiable and it was lawful and reasonable. And he was at pains to explain, on the one hand, he says
the shooting was justifiable, and on the other hand, he says
that prompts him to.
He was concerned about.
That's why I got involved. But we also pointed out to him then that he's taking up a different position that he had taken up in the Marikana matter, where he testified saying that his understanding of the role of the minister is to deal with matters of policy. And we pointed out to him, and that's my understanding as well, Chair, but we pointed out to him that there was a discrepancy in how he approached these two matters. In the Cato Manor case, he sought to get involved in operational matters. He obviously denied that he had gotten involved in operational matters, but my interpretation of the minutes is that he had met with prosecutors and demanded that we be arrested, and that was as early as 8th of March 2012, barely before any statements had been taken, Chair.
One would have expected that if the Minister of Police had any concern that the National Prosecuting Authority was not acting diligently in regard to the prosecution of any particular people, that maybe the police had put together enough evidence for, one would have expected that he would raise that with the Minister of Justice, and that it would be the Minister of Justice, if he thought that it was proper to raise any concern, that would raise the concern with the NPA.
Indeed, Chair.
So here, and the notes, if they correctly reflect the people who were there, or if they correctly reflect, if they correctly reflect the people who were there, There is no indication that the Minister of Justice was at that meeting.
Not at all, Chair.
Yes. Do you recall who the Minister of Justice was at that time?
I think it was Minister Masuta, Chair, at the time.
Was it 2012, 2015? What?
2012, no, it wasn't Mr. Masuta. Wasn't it
Maybe Minister
Hadebe?
Hadebe.
Hadebe, that's
Yeah.
right, Chair.
Yeah. Okay, thank you.
Thank you, Chair. If I can then take you to your statement, which is in bundle ZA. We are now effectively dealing with your paragraph references from 77 and 78 on page 24. 24 of your statement.
Yes.
General Booysen, you have made various references to other perceived interferences by Minister Mthethwa. If I can take you to page 146, which is annexed to JWB 13.
Excuse me, what page is it?
147, sorry.
Yes. Yes.
General Booysen, can you identify this document, please?
Chair, it's a letter written by Advocate, I think it was Mahema at the time. It's addressed to IPID, Mr. Angus, and to the person who is leading the Cato Manor investigation, General Mabula. And it's from the Office of the Director of Public Prosecutions, South Gauteng.
Thank you. And what is your observations in relation to this letter?
Chair, it's evident from this letter, it's a request to have a further interview with one of, well, the so-called key witness, Colonel Rajan Iyer. And in paragraph 2, it states, the plan is that we also consult Sikomboso Ndlovu, the gentleman from the Civilian Secretariat in the Minister's office, who was introduced to us by Colonel Iyer on Friday the 5th of October. It appeared from what Sikomboso Ndlovu was telling us that he has a lot of background information or possible clues to unlock some crucial information that we will require going ahead with the case. Chair, I just find it a bit curious that a person from the Minister's office gets involved with an investigation at this level, unless, of course, he was a competent witness in this matter, which he's not. So my conclusion is, and that's why I've added this to my statement, I've already imputed that the minister himself had been involved with prosecutors, which was wrong. But here, someone from his office, from the Civilian Secretariat, also now somehow gets involved with with a witness, Mr. Iyer, which we now know was a dismal witness.
So you're linking it with what you said earlier on, namely, what was the Minister of Police doing, having a meeting with prosecutors? 1. 2, what is somebody from the Minister's office what does he have to do with these matters? That's what you are raising.
That's what I'm saying, Chair.
Yeah, thank you.
Thank you, Chair. If I can then take you to the next
I'm
annex.
sorry, you said, you did tell us, you see this letter, the copy we have at page 147, doesn't show the author, but you did say it was the DPP for Southern Gauteng.
Chair, on the original, or not the original, the copy that I have, I think Advocate Chauke signed the letter, but if Chair would look at the top,
Yeah,
it says with inquiries, GS Mahema. That's Advocate Mahema. So if they follow the same procedure that we do in SAPS, the person drafts the letter, his name is in the top left under
Yes,
inquiries,
yes.
and it's signed off by the head of the office.
oh, so, but this one was signed by who? This one?
If my memory serves me correctly, it was Advocate Chauke, Chair.
Chauke, yeah, okay, thank you. Thank you.
In continuance of your evidence concerning your understanding of Minister Mthethwa's involvement, I ask you to go to page 149, which is annexed to JWB 14 of the same bundle Z, Exhibit ZA.
Yes,
There appears in the middle of the page an email, and I shall read, from Advocate KMA Chauke, sent 12 June 2012, 05:14 p.m. to Cyril S. Mlochwa, CC Toko J. Majokweni, Palesa NP Matsi, Selo Mahema, Raymond R. Matenjwa. The subject is re-indictment, Kaito Manor. What is your observation in relation to this particular email?
Chair, this is clearly a communication between Advocate Simpiwe Malocha. And Chair, I just want to say something about Advocate Simpiwe Malocha, not to confuse matters.
yes.
There's another Advocate Malochwa, he's JJ Malochwa
Oh,
from Gauteng.
oh,
So this Malochwa here, that's Advocate Simpiwe Malochwa, who received this email from Advocate Chauke. I think that was pursuant to the conversations they had about the signing of documents, which Advocate Simpiwe Malocha seems to have been reluctant to do.
oh, the KZN acting DPP at the time.
That's right, Chair.
Yes,
And there were also other issues that they expected him to do. But Chair, the second to last paragraph, Advocate Chauke writes, another issue of concern to me is the delay in you issuing the instruction of the reopening of the inquest in view of the fact that you have been requested to sign the indictment, which must be preceded by your decision to reopen the inquest. And then the following sentence is the one I want to point out, Chair. If this makes you uncomfortable, please indicate so that I may urgently take the matter up with the acting NDPP, which was Advocate Juba at the time, as well as the minister. Now, it doesn't say there which minister it is, Chair. It could be any minister, but
well, when I read this, I wrote on the side, which minister is this?
well, Chair, the only inference that I can draw, given the history of Minister Mthethwa's involvement, his officer's involvement, the only inference that I can come to that he was referring to the Minister Mthethwa. That does not necessarily implicate Minister Mthethwa, but the question that I would pose is, why would Chauke have the liberty to say, well, he wants to take it up with the minister, which would have been inappropriate?
Well, the meeting to which you referred to earlier, and in respect of which you have produced a typed version of certain notes, handwritten notes, indicate that meeting in which the minister is said to have attended with, among others, public prosecutor or NPA people, was on the 8th of March 2012.
That's so, Chair.
And this letter or email is dated 12 June 2012.
A few months later, 3 months
Yeah.
later, Chair.
Yes. Okay. Thank you.
Thank you. And then as the last part to the Mokoro report.
I'm sorry. I think that last paragraph may be important. Mr. Chauke says to, or Advocate Chauke says to Advocate Mlochwa in the last paragraph, I do not want to step on your toes, I was informed that you agreed and arranged with the ANDPP for somebody, and then I don't see outside to do the prosecution of this matter. If you have now a change of heart, please indicate so that we may resolve it as soon as possible. It refers to a possible bringing in of outside people.
That's true.
Yes. Okay. Thank you.
Thank you, Chair. If we may then just turn to, again, Exhibit ZG, which is the Mogoro report. And again, without detracting from the detail of Mozing's version as recorded from page 127 and on, the report then deals with the evaluation of racketeering case law at page 130. In particular, at page 135, it talks to the Booysen case. And just to highlight, Jiba's evidence on Booysen.
Are you back on the Mogoro report?
Yes, Chair.
Okay. What page?
So, Chair will recall that Mozing's version, just missed it now. Mozing's version, without
Okay, I've got it, 127. Eh?
Yes, Chair.
Yes.
And without detracting from the particularity of detail in here, the report continues to deal with the evaluation of racketeering case law on page 130.
Yes.
And in particular, deals with the Booysen case on page 135. To highlight to you, Chair, at page 138, Jiba's evidence on Booysen is recorded at paragraph 430 to 453. And effectively, this section, in relation to the Booysen case as considered by the inquiry, ends at page 143.
Yes.
The only other reference to the Booysen case, or the pertinent sections then, is at page 311 of the report.
Do you know whether Mosing is the one who made the handwritten notes, isn't it?
Yes, Chair.
Do you know whether the issue of those notes and what they mean and who was present at that meeting is covered in any way in the report? I was trying to see whether that is covered.
You could just... There's certainly reference to the notes, to the meeting, Chair. And that reference is at page 128.
Yes.
Paragraph 396 and 397.
Yes.
But as to the notes in itself, I do not specifically recall mention made of such notes.
Well, I see that in paragraph 397 of the report, it says, notably, Mosing does not state that Mahema and other prosecutors from outside of KZN were also at the meeting and had already been tasked with prosecuting the matter. Yes, okay, continue.
Thank you. As alluded to earlier, at page 311 of the report, the evidence related to the cases are then evaluated, and the Booysen prosecution is specifically dealt with under paragraph 6.1.5.1, running from paragraph 1068 until 1078 on page 313.
Yes.
Reference is also alluded to Booysen in page 327. And although it relates to other evidence as such, under paragraph, or clause 7.1, JIBA, reference is made specifically at paragraph 1127.2, where it reads, with regards to the Booysen prosecution, the evidence establishes that she allowed and in fact enabled the independence of the NPA to be compromised. At paragraph 1127.3, it reads, furthermore, in the Booysen matter, despite initiating the prosecution, she did not consult with the DPP, whose approval was required. And when a dispute ensued between Mlotshwa and Chauke, she refused to get involved and assist in resolving the issue. This reflects a lack of leadership. Save to state that the recommendation which has been made on page 335 has since been implemented, Chair, which is public knowledge.
Yeah.
Those are the pertinent sections of this report which deals with Booysen. I do wish to, however, direct your attention to page 345.
Yeah.
It's an annexure of the report, Chair, and it's quite a detailed chronology of events. For the record, in these proceedings, there are certainly dates and events which are informed by this witness's evidence that I believe needs to be read into the record. And with your leave, if I may, I will do so.
What do you want to do?
Just read certain dates and events into the record, which
Yeah,
is
that's fine, yeah. Okay. Important ones.
important to, or not just important, but it's actually informed by the evidence of this witness.
Yeah, that's fine.
Okay. If I could then start on page 345. 23 December 1998, Jiba's application to be admitted as an attorney struck from the roll. 6 August 2000, Jiba appointed as DDPP. Page 346. 29 November 2007, decision to prosecute Zuma is taken by Mshe and McCarthy. 12 December 2007, Jiba suspended from NPA. 28 December 2007, indictment is served on Zuma. June 2008, Zuma launches application to review and set aside the decision to prosecute him. Next page, 347. 12 September 2008, Nicholson J, being Justice Nicholson, hands down judgment in favor of Zuma. 12 January 2009, SCA overturns Judge Nicholson's decision to review the decision to prosecute Zuma. 10 February 2009, Zuma's legal representatives provide representations to NPA. 3 March 2009, prosecution team considered Zuma's representations. Next page, 348. 1 April 2009,
Why would Mr. Zuma's legal representations, when they were made, be relevant for purpose of this witness evidence?
Because this particular witness certainly alludes to certain allegations in relation to President Jacob Zuma, former President Jacob Zuma.
Yeah, but I'm asking why is the question of when Mr. Zuma's lawyers made representations to the NPA about his case, Mr. Zuma's case, would be relevant to Major General Booysen's evidence. Is there anything I'm missing?
Chair, this particular witness makes a submission. And that submission relates to the prosecutorial system. I'm happy to
Yeah,
deal
but
with that.
I didn't understand anything that he has said so far to be to the effect that his prosecution may have been connected with the prosecution or non-prosecution of Mr. Zuma. My understanding was that his prosecution was concerned with the investigations that he or his teams were involved in relating to Mr. Pandey, Colonel Madu, and the Provincial Commissioner of SARS.
As it pleases,
That
Chair.
doesn't seem to me to be connected in any way.
As it pleases, Chair. I'm happy to then exclude such portions and deal with the rest of them, if I may. 11 June 2009, which is on page 348, JIBA refers suspension to Labour Court invoking the Protected Disclosures Act. Next page, 349, 4 September 2009 and 8 September 2009. Mkhwebi and JIBA signed settlement agreements with NPA. 9 September 2009,
On reflection, Ms. September, on reflection, it doesn't appear to me that there's much purpose to be served in just reading those dates because we have got them here.
Okay, not a problem, Chair. It is then placed before the DCJ, and I'm happy to move on.
Yeah, okay.
Sorry. If I can then take you back to your statement.
Some of the dates might be important to emphasize in relation to specific evidence by the witness. So if there is specific evidence by the witness in relation to a specific incident, then you go to those dates to indicate the context.
As it pleases, Chair. We are now on page 25 of your statement, in particular, paragraph 83.
What page did you say?
Page 25,
Okay.
and it's Exhibit ZA. If I can ask for the following slide to be shown, and that is slide 3. Sorry, slide 4. Excuse me.
Is that a slide we have not seen before?
Yes, Chair.
We have not seen.
No, we haven't seen it as yet.
Okay.
We could, Chair, you could find a copy of that slide in Exhibit ZD.
Is that D?
Yes.
Okay. Is the point to be made, is the slide quite important for the point to be made, to be shown?
Yes, Chair.
Okay. Thank you. What page on ZD?
It's ZD, page 4.
Yes, thank you.
So if we could look at ZD, page 4, while the witness then addresses his evidence from page 83 in his statement. Okay. The next theme of your evidence, General Booysen, is that you address prosecutors and individual prosecutors within the system. Or those who
I'm sorry, just repeat that. I didn't hear. Just repeat that.
The next
The
theme
next theme, yeah, is
of General Booysen's evidence is that he now addresses prosecutors, individual prosecutors within the system in the context of the investigations, the 4 investigations that he has given evidence to.
Okay, he will give evidence about certain prosecutors now. Okay?
Yes, Chair.
Yes.
General Booysen, the slide before you is a combination of 4 interlinking circles and 1 circle which is marked periphery.
That's
Can-
correct, Chair.
Can you please explain what this slide represents?
Chair, in my statement, I tried to articulate what's
Yes.
in this diagram.
Yes.
There were a number of investigations, the Panda
Yeah.
investigation,
Yes.
which I've testified about, the
Yeah.
Amigo case, which I've testified about, the Cato Manor investigation, which relates to the investigation against myself and Cato Manor,
Yes.
and then also the looting of the Secret Services account case.
Yes.
The point I'm making here, Chair, is that invariably, in all these cases, the same prosecutors appear as prosecutors
Yes.
for the state.
Yes.
Well, in the Panda investigation, certain prosecutors, let me start with the Cato Manor one, Chair. The prosecutors that are mentioned under Cato Manor also figure in the withdrawal of charges in the Panda matter and the Amigos case. Also included in my statement, Chair, which is not part of this diagram, is that in other cases that I have knowledge of, such as the so-called rendition case against Shadrach Sibia, the general, and General Onwa Dramat, which subsequently also led to the suspensions of Mr. McBride for a so-called second report that he had changed. The SARS matter, the so-called rogue unit of Mr. Johan van Lochenberg, Ivan Pele, and Mr. Pravin Gordhan. Inevitably, the same prosecutors are always involved with those prosecutions. On the one hand, they prosecute people like myself, Pravin Gordhan, Johan van Lochenberg, Anwar Dramat, Shadrach Sibia, Mr. McBride, Sissoko, Kuba. I can't recall who the prosecutor against Glenys Breitenbach was. So you have this group of prosecutors always involved in the prosecutions of people that are busy with investigations of corruption.
Yes.
In the SARS matter, Mr. Johan van Lochenberg, Ivan Pillay, and Pravin Gordhan, that's been well documented in the media. They were running a parallel investigation into some of the subjects that we were investigating,
Yes.
criminal matters.
Yes.
I just find it very odd that the same prosecutors
Yes.
are always involved in prosecuting,
Yes.
I would call them the corruption busters.
Yes.
And then some of the same prosecutors are then involved in the withdrawal of charges against people that we have been investigating that had already been prosecuted.
Well, you were referring to the fact that you deal with this in your statement. I don't know whether you would like to go to your statement and mention which prosecutor was involved in which matter and so on and so on.
In fact, Chair, if I may,
Yes.
the diagram before you
Yes. I saw that it
Presents-
does have, but I got the impression that I may be wrong. It seemed to have, I thought it had only a few. I thought he might be having more people in mind. I'm not sure. Does it
Chair.
have all?
Yes, Chair.
It has all
Yes.
Oh,
In fact,
okay.
it's a representation of
of what is in
all
the
of the
statement.
prosecutors that he is about to deal with individually.
Yes.
And-
Yes.
And the scheme of this particular diagram is that Panda investigation is the blue circle, Amigos case is the red circle, looting of Secret Service account is the yellow circle, Cato Manor is the green circle. Where these circles then interlace, those would
Yes,
represent
I
common
think-
prosecutors?
I think the point that Mr. Booysen you want to make, I don't know if you are confident that you have made it sufficiently clearly. Or maybe Mr. September was still going to come to it to simply say, in prosecutor so-and-so, Edward so-and-so was involved in that case, and that case, and that case. This is what he did in that case. In that other case, he was also involved, and this is what happened in that case. In that other case, the other one was involved, and that's what he did. I thought maybe that might be what you wanted to say, but you might or might not feel that you want to.
Chair, I'm scared that I might leave out some points.
Yes.
And that's,
Do you want to read your statement? Because you
I'll just refer to it, Chair, I won't read it.
Yeah,
I'll
okay,
to
just
the
refer to it to refresh your memory.
So, Chair, what I've done is I'm naming certain prosecutors
Yes.
that I feel were not necessarily state capturers, but
Yeah.
enabled state capturing.
Yes.
And then after that, I deal with specific individuals within the
Yes.
Hawks
Yes.
that I would say enabled state capture,
Yes.
and then also to a lesser extent
Yes.
the SAPS
Yes.
members who enabled state capture.
Yes. Yes.
So, Chair, if I should start
Yes.
with Advocate Nonkobo Chiba.
Before we get there, if I may, at page 26 of your affidavit, you allude to the Priority Crimes Litigation Unit.
I do, Chair.
There's already been evidence placed before this commission in relation to that through another witness, but can I ask you to just clarify and explain what you mean by highlighting this particular unit?
Chair, the PCLU, Priority Crimes Litigation Unit, was created by Presidential Proclamation on the 23rd of March 2003. Now, their focus should be genocide, crimes against humanity, Foreign Military Assistance Act, Intelligence Services Act, and international terrorism. The point I want to make here is that I find it very strange that some of the prosecutors from the PCLU would involve themselves with investigations against the likes of McBride, Dramat, Shadrach Sabia, for cases, I won't say they're not serious, but they are relatively much less serious than the things that they should be dealing with. Such, for instance, they would prosecute certain people that are now mentioned for fraud. That does not fall into the remit of what they should be doing in the first place.
Yeah, part of the point you are making is they were created for purposes of dealing with very serious matters which fall within a certain category. You know, genocide you mentioned, and you mentioned others, and you say, but they were now involving themselves in matters that in terms of priority, you wouldn't expect them to be really involving themselves in. That's the point you make.
Absolutely, Chair, and I'll refer to this later on again when I talk about law enforcement.
Yes.
Within the Hawks you have, and I'll deal with that later, you have crimes against the state,
Yes.
of whom Brigadier Kaba is the head,
Yes.
also involving themselves
Yes.
with these, I won't call them menial investigations,
Yes.
but much less serious
Yes.
investigations.
Yes.
Chair, I just want to point out, this statement of mine I deposed to last year November already.
Yes.
Well, I compiled it in last year November already.
Yes.
And in the statement of mine, I mentioned that those prosecutors should be dealing with cases, and that's before I heard the evidence of Mr. Agrisi. I didn't even know who Mr. Agrisi was. And here in my statement, I said that they should have been dealing with matters such as Booysen, state captures, the Guptas, Steinhoff, all those cases which seriously affected the economy of the country. But yet they choose to involve themselves with investigations against people that are investigating corruption. Not all of them are from the PCLU, Chair, some of them.
Yes.
And but they work closely together with the prosecutors that I will address
That
in
you
my,
mentioned, yes.
my statement.
Okay.
If I can then take you to page 27 of your affidavit, and paragraph 89 in particular.
Paragraph?
So page 27, paragraph 89.
59 or 89?
89, Chair.
Page 27.
Page 27 of Exhibit ZA, which is the affidavit.
Okay. I know
So
we
we'll
have
work
to
through the
juggle
affidavit
with all
now.
of these, with these 3 lever arch files here. ZA.
ZA, it's the statement, or
Okay.
affidavit rather.
And what's the page 27?
Page 27,
Okay. Yes.
paragraph 89.
Maybe before you proceed, we are at either 1 minute to 4 or 4 o'clock. Normally we would stop at 4 o'clock. But if you're not too tired, Major General Booysen, I'm quite happy that we continue maybe for another hour to try and cover more ground.
I'm good with that, Chair.
Is that right? Is that fine with you?
As it pleases, Chair.
Okay, thank you. Let's proceed then.
At paragraph 89, you make a certain assertion in relation to your view based on your experience within the police. Please explain your view to the Chair.
Chair, in this paragraph, I make the assertion that these prosecutors that I'm mentioning in my statement acted at the behest of Advocate Jiba, who was doing the bidding of the then State President, Mr. Jacob Zuma, and also Richard Ndluli. When I consulted with Advocate September yesterday, she said to me, it's a wild statement to make, and I have to at least substantiate that. And Chair, I would like to do it in the following way. Just mention a few things over and above what transpired and evolved over the last couple of years. The inescapable conclusion, that's the inescapable conclusion that I come to, but I would like just to point out a few things. When Advocate Jiba was part of the team that arrested Advocate Gary Nel during this Jackie Celebi trial.
Well, I guess you mean authorized the arrest, or I don't know if she would have authorized.
No, I think she...
Because it's the police who would arrest,
yes,
isn't it?
Yeah, rather not coincidentally, the same General Mabula who arrested Gary Nel also arrested me in conjunction with Jiba.
Yes.
After Gary Nel, the case against Gary Nel was withdrawn, Jiba was suspended for a role in his arrest.
I'm sorry, I didn't hear that.
After Gary Nel, the case against Gary Nel was withdrawn.
Yes.
Advocate Jiba was suspended.
Suspended, yes.
For her role in the arrest of Gary Nel.
Yes.
She challenged the matter in the Labour Court.
Yes.
And strangely, the person who came to her aid there and who deposed to a statement in her favour was Richard Ndluli.
Yes. So there was an affidavit in her application to the Labour Court, and there was an affidavit included in her application that had been deposed to by Mr. Ndluli.
I don't know the exact extent of the statement,
okay.
Chair, whether it was a confirmatory or whether it was his own statement, but
there was some.
The statement was in favour of
supporting
of Jiba.
Yes, okay.
Supporting the application. The second thing, Chair, I would like to point out is on the 8th of September 2010, the husband of Advocate Nomkobo Jiba, Booker Ntanzi, whom I believe was an attorney. He had been charged for theft of trust money, was convicted. I can't remember what the sentence was, but on the 8th of September 2010, the then President, Mr. Jacob Zuma, expunged his conviction.
Yes.
And the third point I want to make, Chair, to validate my paragraph of 89, and it was a letter written by Richard Mdluli to the then state president in November 2011, in which he says, in the event that I come back to work, because he had now been suspended
Yes.
at the time, in the event that I come back to work, I will assist the president to succeed next year.
This is now 2011.
2011, Chair. November 2011.
Okay. Is that a letter that we have? Or
No, Chair.
no, it's
No.
not a letter we have, but
No.
you know about it.
I know about it, and this was widely reported in the media at the time. Chair.
Yes. Okay.
I think this was just before the Polokwane ANC conference, Chair. I'm not
No,
sure.
Polokwane, if I recall correctly, was 2007. 2012 was Mangaung.
I think it was that one, Chair.
Yes, okay.
So, Chair, having regard to what the evidence leader told me, it's a wild statement to make. I just wanted to mention
Yes,
those are highlights of connections that are that I
that
draw.
you're making.
But
Yes.
there are also other events that
Yes.
causes me to come to that conclusion.
Okay.
Chair, I start off by saying that Advocate Jiba has been at the center of controversy at the National Prosecuting Authority for a better part of a decade.
Yes.
For one, she frustrated lobby groups to have the criminal charges against the previous President, Mr. Jacob Zuma, reinstituted. She frustrated them by releasing the so-called spy tapes. They were eventually, I think, it eventually landed up in the SCA, where they were compelled to release it. She also
So
played.
just to refresh one's memory, the spy case, the spy tapes case, am I correct in thinking that initially what the Democratic Alliance, because I think they are the ones who brought an application to court, what they sought was to be finished with those tapes. And what you are saying is that Advocate Jiba, being acting National Director of Public Prosecutions at the time, would have been the one to make a decision whether to release those tapes or not, but you say she refused. Is that what you say?
She frustrated.
You say she frustrated that process.
That's correct, Chair.
Yes, okay. All right.
Chair, as you would recall, the spy tapes were central to the withdrawal of criminal charges against the
Yes,
previous
yes.
state president.
Yes.
Chair, Advocate Jiba was also involved, and that's come out now in Justice Magoro inquiry,
Yes.
with the withdrawal of charges against Richard Mdluli. She was also involved with. Well, Advocate Linus Breitenbach, who insisted on prosecuting Jiba, was then suspended. Breitenbach insisted on prosecuting Mdluli. She was then suspended by Advocate Jiba. She was found not guilty in that disciplinary hearing after her suspension. That was now
Yes.
Breitenbach.
Yes. I'm trying to remember, but maybe you might remember better. The suspension of Advocate Breitenbach did it relate to her handling of the Mdluli matter, or was it on something else? Or is that a detail that you
Chair,
can't remember?
I cannot recall what they suspended her for.
Okay.
But it's my view, and it's borne out by a number of, for instance, this
In the Mogoro
inquiry,
report, yeah.
that it was Advocate Breitenbach's insistence on prosecuting Mdluli that eventually led her to be suspended.
Yes, okay.
If I may, Chair,
Yes,
in the actual timeline to the report,
sorry?
in the timeline to the Mogoro report,
Yes,
at page 364, reference is made there that on the 26th of April 2012, Mgwebi writes to Breitenbach advising that the MPA should no longer be involved in the Mdluli matter and that IGI is the appropriate entity to deal with the matter. 4 days later, on the 30th of April 2012, Breitenbach is informed that she is suspended by JIBA.
okay.
The other date that
Yes.
you may
But it
find,
doesn't say what she was suspended for, eh? Or does it?
unfortunately not.
Yeah. Okay,
The other date
Yeah.
that was alluded to earlier, in relation to the letter by Mdluli to the former president, in the timeline at page 355, it is recorded on 3 November 2011, Mdluli writes to the president, minister, and police commissioner, indicating that the charges against him are false and based on a conspiracy. He also indicates that he will help the president be successful in the following year's elections.
and the following year's election were not general elections in the country, it was elections of the party, is that right?
Yes.
Of the party
Yes.
in 2012.
Okay.
Okay. Yes, okay.
Okay.
Chair, once Breitenbach was acquitted, that still did not deter then Mr. Advocate Sean Abrams to prosecute her on spurious charges. And the person that then appears on the scene is an Advocate Raymond Matenjwa, who prosecuted her on these spurious charges. Chair, this same Raymond Matenjwa, Advocate Matenjwa, I'll mention it later, and I find it strange that when Advocate Abrams reauthorized my prosecution, on the Monday he appeared in the court here somewhere in Johannesburg. I don't know where Breitenbach appeared as the prosecutor. And that very same Friday he's in Durban.
Oh, yeah, I think you mentioned sometime.
That's
earlier.
right, Chair.
Yes, thank you.
At paragraph 93, you deal with Advocate Jiba's role in prosecuting you for racketeering, but you have certainly dealt with that in extensive detail earlier.
Okay.
At page 29, which is paragraph 94, you deal with additional involvement of Jiba in process. Can you please deal with that part?
Chair, obviously through the nature of the work that I do and having known a number of prosecutors, I engaged with them and I spoke to a number of them. And the feedback that I would get from the prosecutors that at the National Prosecuting Office in Pretoria was like a battleground. There were two factions. Those who wanted to prosecute independently without fear or favor, and then there was what, and I've written a couple of articles about which I would refer to the cabal. When Advocate Nkasana was appointed, it was clear from media reports that both advocates, Jiba and Mgwebi, have become extremely recalcitrant with regards to Advocate Nkasana. He actually, much later when I eventually met him, confirmed that to me in person. And to that extent, he invited a retired Constitutional Court Judge, Mr. Yaqub, Justice Yaqub, to try and establish what was going on at the NPA. And it emerged during his attempt, during that inquiry, that both Mgwebi and Jiba had been extremely recalcitrant, to the extent that I think in the end he recommended a judicial commission of inquiry. Chair, a number of disparaging remarks have been made against Advocate Chiba. I think all that came out in the Justice Magoro inquiry,
Yes.
so I will not deal with that now.
Yes, okay.
Chair, then I conclude the section with Advocate Chiba that that she had been suspended, that there was an inquiry, but the events have overtaken my testimony, so
Yeah.
we now know that the
Yes.
state president has dismissed her. Chair, then I'll move on to Advocate Sello Mahema.
Before we move on to Advocate Sello Mahema, I just wish to alert you, Chair, that mention has been made of the Justice Yaqub Fact-Finding Commission in the Magoro report as well, at page 317.
Yeah, okay.
Chair,
Yes.
when I met Advocate Mahema the first time, he looks like a wise old man. He started to get a bit grey, and he's like a gentleman.
Yes.
And in the beginning, I thought, my view of him was that he's a wise old man. But it emerged later to me that he either wasn't wise or he had been captured. Because invariably he seems to be, and I describe him to the go-for person whenever there's a problem with certain prosecutions. And I highlight some of those prosecutions. I've referred earlier on to the statement that he made in the criminal investigation against Chiba, in which he lied under oath to say a witness had been killed.
Chair, if I may, it's just been pointed out to me that again in this Magoro report at paragraph 253, page 85, it is recorded that Breitenbach was involved in the prosecution of Mdluli, to answer the
Yeah.
question as you've
Yes,
raised
no, I
earlier.
think that was made clear. What I wasn't sure about whether there was anything in the letter of suspension that indicated whether the suspension was linked to her handling of the Zule matter. But you may have read something that suggested that that was the case. I can't remember, but I'm sure you will check.
No problem.
Yes.
Chair, I've already covered paragraph 101 with regards to the fabrications in the prosecution memorandum by Advocate Mahema to prosecute myself and members from Cato Manor. Well, the fabrications, the omissions, and the misrepresentations. I'm also aware that Mr. Johan van Lochenberg, one of the accused in the so-called SARS matter, had also lodged a complaint against Advocate Mahema. According to Advocate van Lochenberg, he also lied under oath in an application which Mr. van Lochenberg had brought in Gauteng High Court.
Can you just please clarify, who do you say lied under oath?
According to Mr. Johan van Lochenberg from SARS, who's also been prosecuted, he filed a complaint with Advocate Abrams against Advocate Mahema and Advocate Mzinyati, in which he accuses, that's where van Lochenberg accuses Mahema also of lying under oath. I have not independently verified that, Chair.
Yes. Okay.
And then, Chair, he also gets involved with the so-called rendition case against Mr. McBride for apparently updating the report. Now, Chair, that case went to court and eventually it was withdrawn.
At paragraph 105, you talk about the suspensions of Mr. Rugby McBride, General Dramat, and yourself were held to be unlawful in courts whilst the others did not challenge their suspensions. And it was consequent to these persecutions, various Hawks and SARS investigations were compromised. Which investigations are you specifically referring to, in your view?
Well, Chair, I've already given evidence that in my absence of 2 years, that the Panda investigations had become dormant. With regard to the SARS investigations, Chair, what happened is I was oblivious to the investigation SARS was busy with. I was invited to the Nelson Mandela Foundation by a journalist to attend to a meeting. And when I asked her what the meeting was about, she sent me a text message. And the invitation basically read, only if you're invited, you can come to this meeting. So I said to her, well, I'm not invited. She said, no, but you're one of the subjects of discussion. And I said I would get you there. So I arrived there, and as I walk in, I saw Mr. McBride there, so I thought, well, at least there's someone that I know here.
This is now at the Nelson Mandela Foundation
Yes, Chair,
offices?
in Sandton,
Okay, all right. And you said you got the invitation from
from a
who?
journalist.
From a journalist?
That's-
Okay, yes.
And Chair, when I walked in, we all recognized each other, but we've never met before. We recognized each other from media articles and photographs.
Yes.
Johan van Lochenberg, Ivan Pillay, all the usual suspects were all there. And then it was the University of the Witwatersrand in conjunction with various other universities. They were doing an investigation into state capture. And there's a professor, I think Lipkin or something, he was leading the discussion. But during the discussion, each one of us had to make a small presentation where we fit into this story. And then after that, we decided amongst ourselves to have a separate meeting and then to bring all our notes with us. And it's at that point where, as myself, Van Lochenberg, Pillay, and company were talking, and General Dramat also eventually joined us in the meeting. He did not attend the first one, he sent his brother. It became clear at that point that we were doing criminal investigations, and simultaneous to that, SARS were doing SARS investigations against a number of individuals that we were also investigating. And that's why I always maintain that the Cato Manor story, the Cato Manor Death Squad story, the SARS Rogue story, and the so-called rendition story, they are inextricably linked.
At page 106, you talk about Advocate Mahema's involvement in the Brett Kebbel matter.
Yes, Chair, he publicly took responsibility in the media for changing the prosecutors at the time, which was, I think, Gerry Nel and Andrea Johnson, who's still with the National Prosecuting Authority. And not surprisingly, Mr. Kebbel was eventually acquitted. He was also involved with the charges against Mr. Mpegu, who was a senior police officer, who was charged for defeating the ends of justice after he allegedly interfered with a witness, Mr. Agliati. I understand that matter did not proceed either. And then I conclude, Chair, by saying it can be no coincidence that Advocate Mahema, having been from Mabatu, I think, gets roped in, to use their own phraseology, gets roped in the prosecution of Booysen, Dramat, and the likes that I've now detailed here. And in the process, in litigation, he's perjured himself on more than one occasion. I've opened criminal cases against him, and he actively attempted to defend Advocate Jiba. Chair, if I could move on to Advocate Anthony Mosing.
Mosing, yes.
Just in line with the slide that we have before us, Advocate Mahema was involved in the Cato Manor investigation only, in relation to those 4 investigations at least.
That's right, Chair.
Thank you. Could please proceed then to Advocate Anthony Mosing.
Chair, I just want to add one thing about Mahema. It's my understanding that a number of these prosecutors, including him, I see Justice Mogoro addresses that. I have not gone into the detail, but there have been suggestions from other prosecutors that their appointments to prosecute in KZN was irregular, and Mahema was one of them.
Okay.
Chair, Advocate Anthony Mosing, his name started to feature with the withdrawal of charges against Mike Maibekulu and Peggy Ngoyeni. At the time, the investigating officer, Colonel P. Deploy, with the forensic auditor, I think it was Mr. Trevor White, I cannot recall, was summoned to the office by Advocate Mosing. And there they indicated to Deploy that the case is not very strong. And I recall Deploy at the time reported to me that they were summoned to Pretoria, and it was clear to them that they already had made up their mind. He said to me at the time, at the conclusion of the meeting, he basically said to them, he doesn't see the need for this meeting because it looks like they're not going to proceed in any event. So I think that's where the stage was set, and the ball started rolling for the eventual withdrawal of charges against Mike Maibekulu and Peggy Ngoyeni by Advocate Noko,
Yes.
in KZN.
If we could then move to page 34 of your affidavit, in paragraph 1110, at which you deal with Advocate Moipone Noko.
Chair, I think I've already alluded to that. In my view, Advocate Noko was appointed, and at least one of the points has been confirmed by Justice Mogoro, Advocate Molocho was removed and replaced by Advocate Noko, to do what Advocate Simpiwe Molocho refused to do, and that's to sanction the application for racketeering charges against myself and Kate Manor.
And this was the same Advocate Nok who was then appointed and who refused to withdraw the racketeering, apologies, who facilitated the withdrawal of the corruption charges against Toshan Pandey.
She withdrew Advocate Noko withdrew the charges against Toshan Pandey and Naveen Madhu.
Okay. And who appointed Advocate Noko?
Chair, my understanding is that those appointments are done by the state president, but the state president wouldn't just out of the blue appoint a person. It must, I suspect it came as after a recommendation by Advocate Juba.
Yes, it would be important to check whether it's the president who makes the appointment or the NTPP. But so maybe you can check overnight.
Will do, Chair.
Yeah.
Okay.
Including acting appointments in regard to such positions as DPP. The NTPP one, I'm sure, is made by the president, but the DPP one, I'm not sure, so you might check about that.
Will do, Chair.
So, Chair, the three main points I'm making with regards to Advocate Noko.
Yes.
She was put there as a proxy. She
Yes.
had to facilitate the withdrawal of charges against Pandey Madhu, which eventually happened. She had to withdraw the charges against Maibekulu and Ngoyeni, which she eventually did. And then she also did what Simpiwe Molocho refused to do, and that's to recommend my and Kate Manor as prosecution.
Chairperson, on whose proxy did Advocate Noko act according to your submission now?
It would have been Advocate Jiba, because Advocate Jiba is the one who wanted Advocate Molocho to sign my
The
prosecution.
recommendation for your prosecution.
That's right, Chair.
Yeah.
Thank you.
And then a year later, Advocate Norco was appointed permanently as the DPP by the state president.
Yes.
And then I've already testified with regards to Norco's role with Advocate Mahema in the misrepresentations and the falsehoods in the prosecution memorandum and the PowerPoint presentation to have us prosecuted.
And in particular, the criminal act, the criminal complaint that you laid pursuant to that.
That's correct, Chair.
Okay.
I've detailed those in my affidavit, which is attached to my statement. Chair, in the recent interviews that were televised for the appointment of a new NDPP, Advocate Norco was one of the shortlisted advocates.
Yes.
And one of the panelists asked her about the Booysen matter. And her response was that she had found it on the court roll when she got there, almost absolving herself of any involvement. And when I watched this, I just thought to myself, how can a person who knows that this has been broadcast nationally sit and lie to a panel like that? She had signed both the covering letters for Mine Manus prosecution.
Yes.
So I think she misled the panel there by saying to the panel she found the thing there on the court roll.
Yes. Because it can only be on the court roll if there's been an authorization of the institution of prosecution. And you say that she recommended the authorization of prosecution.
Chair, the objective evidence is that she signed both those
Yes.
covering letters, and then she tells the panel she
Yes.
found the thing there when
So you say what she said is contradicted by objective facts.
Yes, Chair.
Yes. Thank you.
At page 36, you then deal with Advocate Dr. Tori Pretorius. Can you please address the Chair in relation to your observations of the matters that Pretorius was involved in?
Let's go back to the last point you were making about Advocate Noko. So during her interview when she was a candidate for the position of NDPP recently, she was asked about the matter relating to you by one of the panelists. And she said when she became acting DPP, the matter was already on the roll.
I think the words she used, Chair, is she found it on the court roll.
She found it on the court roll.
Yes, Chair.
Yeah. And that was the end of that line of questioning.
That's correct, Chair.
Yes. So your understanding is in that way she was making sure she would not be asked about any decisions she took to recommend.
That was my interpretation of what she was saying, that she did not want to go there because
Yes.
I think that possibly would have led to other questions.
Yes. Okay.
Thank you, Chair. At paragraph 36, you talk to Advocate Pretorius, Dr. Tori Pretorius.
I think it would be important to get a copy of the transcript of her interview, if we don't already have it here, so that we can have a look at whatever may be relevant that transpired during her interview, including the point that Major General Booysen is mentioning.
And that's specifically, to make sure I understand this, that's specifically the transcript of the interview of Advocate Norco?
Yes, of Advocate Noko. She's the only one that, because Major General Booysen is saying she was asked about the matter relating to him, and she said she found the matter already on the court roll, and Major General Booysen says that's false, there are objective facts which show that it was not on the court roll when she came, and she is the one who did the recommendation. So it would be good to find out exactly what the transcript reflects.
Thank you, Chair.
Thank you.
Chair, with regards to Advocate Tory Pretorius, I describe him as a lightning conductor in my statement. You have these prosecutors like Mahema and Noko and Mozing and a few others that are in the coalface
Yes.
in the courts. But in the background, you have Advocate Tory Pretorius giving legal opinions, and invariably those opinions are against the likes of myself, Pravin Gordhan, etc. Both him and Advocate Msinyati, and I think it is Advocate Abrams as well. Well, it was Advocate Pretorius, Msinyati, and Abrams. Yeah. They received notices of intention to suspend them by the then president for their role in the aborted Minister Pravin Gordhan matter. They were eventually not suspended, but I think it would be interesting to know what is written in their presentations, because that might indicate where the decision to prosecute Mr. Pravin Gordhan were politically motivated or not. But be that as it may, Chair, the fact that Mr. Tory Pretorius had involved himself and aligned him with the prosecution of Mr. Pravin Gordhan, and we now know which it had catastrophic effects on the economy of the country. And as I previously alluded to, the fact that the PCLU, of which he is a member, these investigations do not fall into the remit of the PCLU, but he constantly seems to get himself involved, or either by default or by design. He also gave a legal opinion in the Cato Manor matter when we brought in an application to have the matter struck of the roll, when he aligned himself with the prosecutors, Mahema at the time.
Yes.
The next prosecutor that you then, the next advocate that you deal with is on page 37, and that is Advocate Raymond Mathenjwa.
Chair, Advocate Raymond Mathenjwa was the initial prosecutor when the first batch of Cato Manor members were arrested. I wasn't present at court. I had a commitment with members from the FBI in the USA, in KZN. But on various occasions, he opposed bail. On various occasions, he had to be called to order by the magistrate for his ethics in court. He's involved in my investigation. He's been, like I said earlier on, he was also involved in 1 week going to court for Glennis Breitenbach, and during the same week in a different province for my matter. I've been told by two very senior advocates from the National Prosecuting Authority that there was a letter where a number of prosecutors had been promised promotion by Advocate Abrams at the time. I never saw this letter, but two independent advocates told me about this. And Advocate Raymond Mathenjwa was one of them that was going to be promoted to a post at Nelspruit, where a new post was to be created. My understanding from these two senior advocates from the National Prosecuting Authority is that Advocate Abrams had already drafted the papers, but it was at that time when the then state president was under pressure and he resigned. So he had not signed off on that, which eventually negated the promotion of these prosecutors, of which Mathenjwa was one.
Now, the relevance of the promotion, of their promotion, is it that the promotion was linked to the work they were doing in relation to the prosecution of people like you, or it's just being mentioned?
Chair, the people that were mentioned, majority of the people that were going to be promoted are some of the prosecutors that I deal with in my statement.
Yes, okay. Now, the people from within the NPA who gave you this information, do you have any idea whether they would be prepared to come and give evidence of that to the extent that it may be deemed necessary? Or is that something you don't know?
Chair, the one might not, the other one might.
Okay. And you will give the names to the legal team?
I will, Chair.
Thank you.
At page 38, from paragraph 1 to 4, you deal with the next advocate, who is Advocate Sean Abrams. Who appointed Advocate Sean Abrams?
Oh, Chair, it's common cause that he was appointed by the state president.
Okay. Who preceded, who was the previous incumbent to his position?
That was Advocate Booysen Kasana, Chair.
Okay. And what was Advocate Booysen Kasana's view in relation to the withdrawal of criminal charges against Mr. Toshan Pandey?
Chair, obviously,
Against who?
Mr. Toshan Pandey.
Oh, okay.
Chair, I don't think he had a specific view, but he facilitated, after I directed my letter to him, he facilitated prosecutors to
review of the matter.
reevaluate.
Yes.
So, in my view, those were one of his sins, that he was prepared to have all those cases that had become dormant to make them alive again.
Yes.
The second sin I think he committed was, it was under his stewardship that Advocate Nonkobo Jiba was prosecuted.
Yes. Yes.
And that's borne out, Chair, by, and I refer to that in paragraph 127 of my statement. I was watching the evidence of Advocate Mohofe,
Yes.
where Advocate Mohofe stated...
In this commission.
That's correct, Chair. Where he stated that the then Minister of Police, Minister Nati Nhleko, had informed him that there's going to be an audience with the state president,
Yes.
which eventually happened. And during this conversation, in spite of the fact that he had no relevant experience as a prosecutor, never mind to head the National Prosecuting Authority, that the president wanted him to become the new NDPP. That was while Advocate Nkasana was the NDPP.
Yes.
And what struck me of his evidence, Chair, and that convinced me more than anything else, that one of the cardinal sins that I also committed was to be the complainant in the matter against Advocate Jiba. According to Advocate Mohofe, the state president was not happy with the fact that she'd been prosecuted. And in fact, he offered him to become the NDPP. And I think the words that he used is that he would be the Euro NDPP, but Jiba was going to be the default.
The de facto, yeah.
I think
The
he used
de
the word
facto
default, yeah.
entity, yeah, yes.
The default DPP, as long as Jiba was left alone. Chair, with regards to Advocate Abrams, when he assumed office, two of the very first things he did was to call advocates Ferreira and Van Eden, because they were the prosecutors appointed by Advocate Ngasana to prosecute Advocate Jiba. and he wanted an opinion from them as to the strength of the case. And I'm aware of this, Chair, because those documents were attached to another application. I think it was in the Western Cape. He procured that from the two advocates himself. And on a reading of that, Chair, it's blatantly evident from their opinions that there is a case to be answered by Advocate Jiba. The other thing that he did was to ask Advocate Gerry Nel about the Pandey matters. That was in 2015, Chair. And my understanding is that Advocate Gerry Nel had made certain recommendations that a number of people in those investigations are prosecuted. So that was the very first thing he did, and we now know what's happened to those investigations. None of those people to date have appeared in front of a court. And with regards to the first one I was mentioning, with regards to the Jiba matter, that eventually, Chair, the trial was supposed to commence, I think it was on a Wednesday, and I was consulting with the prosecutor the week before that, and we had to work from his files because the prosecutor told me the docket was with Advocate Mogatle, Marshal Mogatle, I think his name is. But what later emerged was that Ferreira had written an email to Mogatle to tell him, listen, I need my docket. I'm consulting with a witness. The trial is about to commence. And Mogatle's response to that was, in an email, that the docket is with the NDPP, obviously Mr. Abrams, and that they should have an answer by the following day. Which makes me think that because subsequent to the withdrawal of charges against Jiba, they announced that the charges were withdrawn by Advocate Mogatle. But I firmly believe that they were actually withdrawn by Advocate Sean Abrams. And that was confirmed in an application to the High Court. I cannot recall whether it was Freedom Under the Law or whether it was the Helen Suzman Foundation. There, the judges all held, I think it was a full bench, Chair. All the judges held there that in spite of that fact that Mogatle and Mahema deposed to affidavits under oath, that it was Mogatle that withdrew the charges and not Abrams. The court found that it was indeed Abrams who withdrew the charges and not Mogatle.
Yes.
And Chair, not surprisingly, you have a High Court finding against Advocate Abrams, and the judges even in the judgment says it raises questions about integrity. And they also make other adverse remarks against Advocate Abrams and Advocate Mogatle. And I just find it curious that up until today, in spite of those negative aspersions cast by High Court judges, absolutely nothing has happened to Advocate Mogatle and Advocate Abrams, neither from the employer at the time, who was the NPA, and neither from, well, the then GCB, and I believe that there's a new body now.
Yeah, yes. Do we have that judgment that Major General Booysen is talking about in the bundle?
No, Chair.
Okay, it should be secured. We should have that. Is your recollection that in that matter, Advocate Abrahams had also filed an affidavit?
Yes, Chair.
And whether his affidavit was saying that it was Advocate Mogatle who made the decision to withdraw?
That's right, Chair.
So, but you say 3 judges rejected that version
Yes, Chair.
and said it was him who made the decision.
There was a minority, there's a majority and a dissenting judgment,
Yes.
but all the judges
Yeah.
held that, or found
Yes.
that it was in fact Abrams who withdrew the charges and
Yes.
not Mogatle,
Yes.
in spite of the fact that both deposed to affidavits
Yes.
in opposing the application.
Yes. And do you know whether that matter is somewhere in the court system with appeals or not, or is there something you don't know at the moment?
Chair, obviously what happened with,
So basically what I'm looking for is whether those findings still stand or whether they're subject to some appeal.
no, Chair,
as we talk.
sorry, Chair, the court held that the withdrawal of charges by Abrams was irrational.
Yes.
And to my mind, the
Yeah.
criminal charges should be reinstated.
Yes.
But to date, none of that has happened.
Yeah.
I found out through the Justice Magoro inquiry,
Yeah.
when they were pushed for an answer, Jiba's counsel then said to Judge Magoro, they're going to establish what happened. And then the following day, they handed in a letter from, I think he's from Advocate Smith, I can't remember which province he was from,
Yeah.
Northwest, which he said that, so obviously Advocate Abrams had referred it to another advocate again, who then said, no, there's no reasonable chance of a successful prosecution.
Yeah.
In my view, he did not have the authority to review what the two other advocates had already established.
Okay, we need to have that judgment, and it may be that depending on when one reads the judgment, it may or may not be necessary to have a look at one or more of the affidavits that may be affected on that issue.
As it pleases, Chair.
Yeah. Okay.
Were you involved, General Booysen, in the legal process which led to Nomgcobo Jiba's prosecution?
Chair, I was the complainant.
And that related to your case, her role in your case?
That's correct, Chair, because in the Govan matter, I accused her of being mendacious, and she did not respond to that. And it was based on that and the findings of the court that I laid the charges. And I was privy to the charge sheet because she was going to be charged for perjury, for lying under oath in that statement in the litigation process. She also misrepresented facts, which comprised, which I would say makes her guilty of fraud, and then also for defeating the ends of justice.
In your view, did you suffer any consequences as a result of laying this complaint against Advocate Jiba?
Chair, in my view, when I took early retirement 5 months early, not that I'm retired, Chair, I'm still working. Chair,
Yes.
in my view, and that's how I feel about it, if I just kept my mouth shut and either taken that golden handshake by General Piega and disappeared into the sunset, they would have forgotten about Johan Booysen. The fact that I went back and reopened all these cases and Advocate Jiba was now prosecuted, I'm convinced that that prompted the reaction that I eventually experienced, that I was now re-prosecuted by Advocate Sean Abrams. Chair, all the evidence, or should I say the lack of evidence, had been ventilated in front of Judge Govan. And he's very emphatic in his findings. My assertions that the witnesses that they referred to, Ayer, Danikas, Londlo, every single one that Abrams now purports to rely upon, the judge there held, over and above the fact that some of those statements weren't even signed, but even if they were, does not link me to the offences I'm being prosecuted for. Yet Mr. Sean Abrams uses the same statements with the addition of one. The statement of the Greek citizen in the Jiba application was never signed. And even if it was signed, Judge Govan said it does not implicate me in the commission of an offence. Advocate Abrams, when I applied to have his authorization to prosecute me reviewed and set aside, in his answering affidavit, he states that he had sent Advocate Mahema and Advocate Dawood Adams to Greece. And they had now taken a signed statement of Danikas, and he says the statement now signed, I was satisfied, and then he authorized my prosecution. Chair, the problem with that is, when I saw that, I said to my attorney, please phone Advocate Mahema and ask him for a copy of the signed statement.
Yes, because obviously it was relevant.
Yes, Chair. Which Mr. van der Merwe duly did, and I was present when you phoned him, and Advocate Mahema's response was, the statement is still in Greek, it's not been translated yet.
It's still in Greek.
It's still in Greek. Chair.
Yes, it hasn't been translated.
It hasn't been translated yet. Chair, as I sit here today, in spite of a number of letters to Advocate Mahema, I still do not have a copy of a signed statement. I understand that it eventually was translated, but that's probably almost a year after Advocate Abrams reauthorized my prosecution, which begged the question, how could he have considered a statement which is in Greek, unless he's conversant in Greek, which I don't think he is.
Is he not conversant in Greek?
Chair, most of this, what they do to me is Greek, but I don't think he's conversant in Greek.
Having said that, General Booysen, if I can ask you to go to page 182, paragraph 39 of the same bundle.
What page?
It's page 182, paragraph 39.
182.
Yes, Chair.
Well, General Booysen, I was asking whether he's not conversant in Greek because, there are people in the country who are conversant in many languages. So, until one knows whether he is conversant in Greek.
Chair, I've actually challenged him in my in my replying affidavit.
Yes.
To which I have not received a response yet.
Is that in a matter that has been finalized?
No, Chair, that matter is pending.
Oh.
That review application.
Yes.
That's pending, Chair.
Yes, okay. So he would have to deal with that in his answering affidavit, or in his affidavit.
He will have to deal with that, Chair, because I actually accuse him also of lying under oath.
Yes.
And I've invited him to file a fourth set of papers.
Yes.
To dispute what I'm saying, that he's not conversant in Greek.
Yes. And do you remember when the time will expire, by when he should file his affidavit? Or is it still coming, or is it gone?
Chair,
you don't have to be exact, I'm just
Chair, I filed my founding affidavit in 2016, immediately after I was rearrested and prosecuted.
Yes.
These proceedings have been occasioned by delay after delay, occasioned by the National Prosecuting Authority.
Yes.
First, they filed the record because we asked for the Rule 53 record,
yes,
which they filed. A week later, they added material,
yes,
to the record.
Yes.
Then about 2 months later, by then I had filed a supplementary affidavit.
Yes.
After I filed my supplementary affidavit, they filed more so-called evidence, more material. To the extent that I think it was 2017 or 2017, where they undertook that because Advocate Jiba also had to file an affidavit. They then undertook, I think that was around about August, that she would file by August. When August came, they dumped a whole lot of new material, which she said she'd forgotten about, which she had also considered 5 years prior to that. By now, that was the third time that they had added material to the record. And we did not agree with that because that's not what the Rule 53 requires of the prosecution. And then we suggested to them that they should apply for condemnation. They refused. We then told them, well, you'll have to. And eventually they conceded that they'll have to apply for condemnation. I think that was around about October, November. But in spite of
October,
agreeing
November 2018 or 17?
17, Chair.
Yes.
But in spite of that, of them agreeing to file, to apply for condemnation, and I think it was November, they only filed it in February the following year.
Yes.
Eventually, Chair, we applied to have the matter struck off the roll because we have appeared 20 times, which 18 times I think were in the High Court, and the case hasn't commenced yet. And it's now after a period of almost 7 years. The matter was not struck off the roll. The judge then, Judge Loeb, said what he's going to do is he's going to take charge of these processes, and he gave certain timelines.
Yes.
All of us have adhered to those timelines, the NPA, and so that we accept on one or two occasions where we would engage with each other because the papers were quite comprehensive. With the appointment of the new NDPP chair, the whole review application or the filing of papers are being kept in abeyance by agreement between the two parties, and the judge president has been informed of that.
Okay, so one is not sure what will happen with the matter in the light of the new NDPP, but still pending.
Chair, so obviously there's a new bus driver, for lack of a better phrase.
Yeah.
The respondent in this matter is the NDPP, it's not the person. So the current NDPP will have to decide whether she wants to proceed with the matter.
Yes.
In which event, if she wants to proceed with the matter, then Advocate Abrams, Mahema, and Chiba will have to file a fourth set of papers if they take up my invitation.
Yes. Okay, thank you.
Sorry, I do note the time, but there's just one particular point, with your leave.
Okay.
Because notwithstanding the fact that it is General Booysen's statement that there has been a reauthorization for the charges under the helm of Advocate Sean Abrams, it is important to place on record that at page 182 of this bundle, at paragraph 9, it is Govan J's finding, or remark rather, and I shall read. It is important to note that the above findings do not amount to a finding that Mr. Booysen is not guilty of the offences set out in counts 1 and 2 and 8 to 12. That can only be decided by way of a criminal trial. Setting aside the authorizations and decisions to prosecute also does not mean that fresh authorizations cannot be issued or fresh decisions taken to prosecute if there is a rational basis for these decisions.
Yeah. Okay, it is 5 o'clock, so we'll adjourn. I think Mr. Paul Pretorius had requested that I consider that we start at 9:30 tomorrow morning, and I think I may have agreed, but I want to change that back to normal time at 10 o'clock, if you can live with that, Mr. Pretorius.
Certainly, Chair.
Because
It's your prerogative.
well, it's more because I'm not feeling too well today, so I might need a little bit of more time in the morning before I come here.
Understood.
That's the only reason. Otherwise, I would not hesitate that we start earlier if it suited everybody, including Major General Booysen. So, if it's fine, let's start at 10.
Thank you, Chair.
Yes. Is that fine with you?
That's fine by me, Chair.
Okay, thank you. We'll adjourn the proceedings for the day then until tomorrow morning at 10. We adjourn.
All rise.